walk you through this topic. Gatekeeping functions under the IBC, claims verification and admissions. I hope my screen is visible to everyone. So we will cover these topics in today's discussion: objects of the IBC, legal structures of the IBC, situation when the claims to be submitted, and different regulations in the CIRP, liquidation, voluntary liquidation, fast track insolvency resolution process, pre-packaged, personal guarantors, bankruptcy, and form filing under the claims, broad CIRP process with respect to the claims, important definitions related to the claims, claim filing under the CIRP and relevant regulations covered and connected with the claim, substantiation of the claims, like submission of the proof of claim, updation of claim, verification of claim, determination of claim, debt in foreign currency. And we will also discuss the case laws, which is related to the claims and the decisions of the adjudicating authority, NCLT and Supreme Court as well. And broad liquidation process in respect of the claims and what are the like procedures and norms and laws in the liquidation with respect to the filing of the claims. And then we will also cover the relevant case laws relating to the claims, which will cover the aspects of the Limitation Act, time barred claim, and claim received after approval of the resolution plans, etc. And we will also cover what the common mistakes we found as insolvency professional when we are examining the claims, and what are the tips for the claimants for the submission of the claims we can give. So this is like the just introduction I would like to give very quickly. Why it is called act means which is passed by the parliament and approved by the president of the India. Why it is called code? Because it is a collection of the laws. It refers to a systematic and comprehensive compilation of the laws, rules, regulations, ordinance. It includes everything. It is consolidated, so it is also called the code. Insolvency, everybody knows, inability of a person or a company to pay the bills or debts as and when they becomes due and payable. Bankruptcy, when a person is declared incapable of paying their dues and paying their bills. Liquidation is a winding up process, total close-up of the corporation or any entity. Who are the governing regulators? IBBI is the governing regulators which govern insolvency professional agencies, govern the insolvency professionals, also govern the information utilities. Who are the educators for us? NCLT for the corporate entities like the companies and LLP, and DRT is the adjudicator for the non-corporate entities which cover the individuals and partnerships. So we already aware about the what is the object of the IBC. The very object of the IBC is to maximize the value of the assets of the interested persons, to provide the painless revival mechanism for the entities, to promote the entrepreneurship, and to balance all the stakeholders' interest. So we will quickly go through the citations, which is related to the core purpose of the IBC. And there are some citations which is given in the Swiss Ribbons Private Limited versus Union of India. In 2019, it was held that the primary object of the IBC is the resolution of the corporate debtor and the revival of the company, not only the recovery of the creditors. And Innovative Industries Limited versus ICICI Bank, we can see that the code aims to resolve the insolvency in a time-bound manner to maximize the value of the assets of the corporate debtor. Point number 3, ArcelorMittal India Private Limited, Satish Kumar Gupta, the core object has been defined that the purpose of the code is the revival of the corporate debtor through the resolution plans. In the matter of COC of the SR Steel India Limited versus Satish Kumar Gupta, it was held that the code seeks the value maximization and the revival of the corporate debtor through a successful resolution plan. We can see that in all the matters, the only purpose is not only the recovery, but there is a revival and resolution of the corporate debtor. So this is the core purpose of the IBC. We come to the legal structure of the IBC. So it is applicable on all kinds of corporate entrepreneurship. Just wait, I will raise the pointer so that it will be easy to point out where I am. So applicability, all kinds of, it is applicable on like companies which is registered under the Companies Act, LLP registered under the LLP Acts. So it is, and partnership forms, there is a different regulation. For the individuals, there is a different regulations. Scope, IBC covers insolvency, liquidation, and voluntary liquidation, bankruptcy. And it is divided into the different parts, which covers part one, definitions. Part two is about insolvency resolution and liquidation. Part third is about insolvency resolution and bankruptcy for the individuals and partnership firms. Part fourth talks about regulation of the insolvency professional agencies and information utilities. And part fifth talks about miscellaneous amendments and there are the 12 schedules. 1 to 11 provides for the amendment to be carried out in the other statutes. There are the corporate persons, NCLT and NCLT and Supreme Court for the corporate persons, and these are the bodies for the individuals and partnership firm, DRT and DRAT, and Supreme Court for the question of law. So ultimate authority is the Supreme Court. Pillars of the IBC is the IBC mechanism is driven through IBBI, IPs, IPA, adjudicating authority, and information utilities. Now we come to the important definitions so that we can walk through the what are the all the aspects and provisions and importance of the claims. So first we will quickly go through the what do you mean by the claim. So it is defined under the IBC under section 2 subsection 6. Claims 26A says that it is a right to payment, whether or not such right is reduced to judgment, fixed, disputed. It can be undisputed, legal, equitable, secured, or unsecured. 26B says right to remedy for breach of contract under any law for the time being in force if such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured, or unsecured. When I am claiming some money, which can be secured, which can be unsecured, which can be disputed, undisputed, it will become my claim. In the Supreme Court, in the Swiss Ribbons Private Limited versus Union of India, it says that claims gives a rise to a debt when it becomes due. And default occurs when the debt becomes due and payable and it is not paid by the debtor till date. This is why the FC proves the default and OC claims a right to payment of the liability. When this is kept in mind, the differentiation in triggering of the insolvency resolution process by the FC and OC becomes the clear. 210 defines the creditor means a person to whom a debt is owed and includes a financial creditor, operational creditor, secured creditor, unsecured creditor, and decree holder. Debt means any liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. It includes secured creditor means a creditor in favor of whom the security interest is created. And then 231 also describes the security interest means any right, title, or interest or claim to property created in favor of or provided for a secured creditor by a transaction which secure the payment or performance of an obligation and includes the mortgage, charge, hypothecation, assignment. It can be in any form or encumbrance or any other arrangement securing the payment or performance of any obligation of any person, provided that security interest shall not include any performance guarantee. Section 5(7) defines financial creditor means the creditor to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. And then financial debt means a debt along with the interest, if any, which is disbursed against the consideration for the time value of the money and includes money borrowed against the payment of interest, any amount raised by the acceptance under any credit facility or it is dematerialized equivalent, any amount raised pursuant to any note purchase facility like the issue of the bonds, notes, debentures, loan stock, the amount of any liability in respect of any lease or hire purchase contract which is deemed to a finance or capital lease under the Indian accounting standards or such other accounting standards as may be prescribed. It can be in the form of receivables sold or discounted other than any receivables sold on the non-recourse basis. Any amount raised under any other transaction, including any forward sale or purchase agreement having such commercial effect. It can be in any form. Any derivative transactions entered into in connection with the protection against or benefit from the fluctuation of any rate or price or for calculating the value of any derivative transaction. Only the market value of such transaction shall be taken into the account. Any counter indemnity obligation in respect of a guarantee, indemnity, bond, documentary, letter of credit or any other instrument issued by the banks or financial institution. or the amount of any liability in respect of the guarantee or indemnity is referred to. So we are discussing some case laws which is related to the financial debt. In the case of Anuj Jain IRP for the JP Infratech versus Axis Bank, it was held that for a debt to qualify as a financial debt under Section 5(8), the essential requirement is the disbursal against the consideration for the time. We will discuss the detailed case law also. This is just, I'm quickly briefing this case law, which what was held in the particular case. So the basic condition for the financial debt is that the disbursal against the consideration for the time value of the money. Mac Pharmaceutical and Chemicals Private Limited versus Accurate Infra Build Private Limited. It was held that there must be a disbursal of the money against the consideration for the time value of the money, even if the transaction is not expressly interest bearing. So there should be some principal in interest, but it is not necessary that it will be the interest bearing. It can be in any other form also. It will also become the financial debt. Operational creditor means a person to whom a operational debt is owed, includes any person to whom such debt has been legally assigned or transferred. Operational debt means a claim in respect of the provisions of the goods or services, including employment, or the debt in respect of the dues arising under any law for the time being in the force and payable to the central government or state government or any local authority. It will become operational debt. So now we will come to the key of what is the claim and what is the importance of the claim, what is the role of the IRP, RP or liquidator in the verification of the claim during the CIRP or during the liquidation. Uh, we will understand and we will discuss, and I hope the members will actively participate in the discussions. So what is the importance? Basically, I would like to say that claims are the backbone of the CIRP because whole the CIRP is based on the claims. The verification and admission of the claim is the cornerstone of the CIRP because the RP or liquidator relies on the claims to determine, because ultimately when any claims received from whether from the financial creditor or operational creditor, it like when it will receive from the financial creditor, then it will be the part of the COC. So ultimately on the basis of the claims we will form the COC, and on the basis of the claims received we will determine the voting shares of the creditors, and as per the voting shares it will ultimately decide the distribution of the proceeds under the resolution plan. So we can say that it is the like cornerstone, and every and a CIRP is basically depend upon the claim procedure, claim verification procedure. So without accurate and comprehensive verification of the claim, the entire CIRP can be collapsed or can face the legal challenges, can face the disputes, can delay the CIRP, can collapse the CIRP, whatever maybe. So we can say that the claims are not just the numbers, they define the control and voting power. They define the control and voting power and the ultimately future of the corporate debtor. What will be? It's depend upon totally on the claims. Secondly, through the claims, when we receive the financial creditors, when we receive the claims from the financial creditors, ultimately we form the COC. The COC is formed based on the admitted claims. We upload the claims on the IPPI. We determine the voting shares which is assigned against the claims, admitted claims. This means that any error or omission we will do, if we will do, it will directly affect the voting powers. It will directly affect the voting ratio. It will directly affect the approval or rejection of the resolution plan. And ultimately, the value realization for all the stakeholders is important, and it will affect the value realization for all the stakeholders. If a legitimate example, if it is a legitimate creditor is excluded, if we will not verify the claim properly due to any reason, and if in any legitimate creditor we exclude due to an unverified claim, we have just forget to verify that claim, the COC may be improperly constituted, and which will affect the whole legality of the CIRP. So it is like what do's and what don'ts we will discuss in detail. So here I can say that there is a very much importance of the books of accounts of the corporate debtor. So whenever the CIRP start or liquidation start, RP take the custody and control of the CD's assets, which include the physical assets, financial assets, books of accounts, financial records. But why it matter? When we take the custody of these assets, it actually matter because without examining the books of accounts, it is impossible to accurately verify the claims. So claims often arise from the like loan agreements, invoices, statutory dues, which are all reflected in the company's books. Ultimately, it will be reflected ultimately where we can verify. When we are having the tally data, when we are having the books of accounts, when we are having the vouchers, invoices, whatever the data maintained by the CD, then accurate. If we are having these copies and these documents, then we can accurately verify the claims because we need the supporting documents to actually determine the amount of the claim. Because incorrect claim admission can distort the total liability of the corporate debtor. Because what is the actual liability? We have to see the proper documents because it affects the ultimately it will affect the resolution plan. So we can say that the books of accounts are the map and claims are the destinations. So without the map, you cannot reach the right destination. Claims determine overall liability. It is very, very correct because the total liability of the corporate debtor is not a guess. It is decided through the verified claims only because every financial creditor, operational creditor, or statutory authority submit the claims that aggregate to form a debtor's total obligations. When we receive the claims, so many claims like from the CD, from the FC, from the OC, FC, statutory authority, government claims, employees claim, workmen claims, class of creditors claims, the RP must ensure that the claims are accurate, substantiated, and reflect the correct principal interest and security interest, whatever connected with the claim. Ultimately, because ultimately the resolution applicant rely on his total liability. Because when the CD is having like 100 crores claim, then resolution applicant will give the resolution plan based on that liability, so that he will like figure out how much extent to how much extent I can absolve this liability, or I can meet this liability, or how I can resolve this corporate debtor, how I can revive the corporate debtor, what will be the future prospects, and etc. So any underestimation or overestimation due to the faulty claim verification, which can lead to the disputes, litigations, and ultimately it will delay the CIRP. Security interest and distribution of the resolution plan proceeds. Each creditor's claim may be secured or unsecured. The RP must determine the exact security interest because when we receive the claim form, there is an option that the claim, whether the claimant having any security interest or not. So it can be the secured or it can be the unsecured. The RP must determine the exact security interest for the each creditor because the distribution of the proceeds from the resolution plan depends on the security hierarchy. Because when sometimes there is an option in the IBC that the distribution of the proceeds can be done on the claim ratio or can be done on the security interest ratio. So if we will not verify the security, like if there is a possibility, then the one charge is created, like one property is mortgaged to the one or more lenders. So we have to verify that properly. So whether the NOC was given to this by taken by the second lenders on the when the charge is created on the same property. So we have to determine the exact security interest. Otherwise, it will lead the dispute at the end and at the time of the distribution, at the time of the approval of the resolution plan. So it is like the very first step to be very clear about the claim verification and admission or rejection of the claim. The resolution applicant allocate the payment because when he submit the resolution plan, he allocate the payment proportionately based on the verified claim only. Example, a secured creditor with first charge must be paid before the unsecured creditors. Incorrect security verification can jeopardize the plan's approval. Because if we will give the less share to the secured creditor and we will give the more share to the unsecured creditor, then it will jeopardize all the process. So claims and security go hand in hand. Without clarity on both, distribution is chaotic and risky. Resolution plans perspective. So resolution applicants, who is the PRA, who is submitting the resolution plan. So PRA submit their expression of interest and eventually they submit the resolution plan, which is based on the actual size of the claims. The first point the PRA says, PRA see that before walking through the step or before walking on the process of the resolution plan, they verify, they figure out what is the actual size of the claims. And what is the security structure means what are the assets available in the corporate debtor and who is having what. So if the claims are incorrectly admitted or omitted, the PRA may submit a suboptimal plan. He may face unforeseen liabilities or even can withdraw from the process due to uncertainty. Because if he will come to know that there are not the certain what is admitted, it is contingent, something is contingent, it is not properly verified, or there is some dispute, whatever, then ultimately he will withdraw from the process and ultimately the CIRP will be delayed and will be collapsed. So ultimately, the success of the CIRPs depend upon the transparent, accurate, and fully verified claims. Incomplete or improper claim verification. So many a times when we see that there are the 100 claims, 500 claims, 800 claims, so there may be the risk of incomplete or improper claim verification. So in that case, if a claim is not thoroughly verified due to the heavy workload or due to the huge claims forms, PRA may miscalculate the payments to the creditors because sometimes we do not, in case of the like large number of the claims, we could not verify the claims, each and every claim in the depth. So it can be like situation can be like PRA may miscalculate the payment to the creditors. COC may approve a resolution plan based on the inaccurate, because if the first step is incorrect, then the next and subsequent steps will be based upon this, and that decision will be taken on the basis of the incorrect claim verification, incorrect initial steps, so that entire CIP will affect adversely. So COC may approve a resolution plan based on the inaccurate claim data. Litigation may arise if the creditor or the PRA challenge the claim admission. CIRP can get delayed, affecting the recovery value. Obviously, CIRP will be delayed. Distribution of the proceeds under the resolution plans become contested. Obviously, if any one lender says that no, my security interest is that, and why I should bear the low admission, why I should bear the lower value under the resolution plan, then it will affect the distribution of the proceeds under the approved resolution plan becomes contested, even it is approved by the COC. Even so, there may be a case कि a single unverified claim can create a domino effect that jeopardize the entire CIRP, because in case you have received the 500 claims, you have verified 499 claims, but Unfortunately, unfortunately, you forget to verify only one claim, and then after the approval of the resolution plan by the COC, that claimant comes and says that no, my claim has not been verified. I have submitted my claim, but the RP has not provided me any updates. Then he can challenge the approval of the plan, and then he can like delay the CIRP very well in case of single and verified claim, because it can become a domino effect. How to ensure a comprehensive verification? So when we can say that we have verified the plan very accurately and very comprehensively. So what are the documents required? Like we have to check the loan agreements, invoices, copy, bills, copy, statutory dues, arbitral award, contracts, verification steps. So match the claim amount with the books of accounts. We can, like when anybody has submitted the claim of rupees 50 lakhs, then we can cross check with the books of accounts available, corporate debtor, bank. We can check the bank statements of the corporate debtor. We can verify the agreements. We can verify the security interest, lien, priorities, what was the charge created. We can check on MCA. We can like GST, we can crossly check like invoices. If the GST is deducted, then we can cross check on the regulatory filings like the GST, PF or tax dues. We can confirm the existence and eligibility of the creditor. So these are the verifications so that we can avoid the unwanted claims. Like we can we can accurately measure the claim, or we can accurately decide the amount of the claim. Best practice. RP should prepare a claim verification report approved by the COC before calling for voting. So ultimately, what we should do, so that we should prepare a claim verification report and we should show it before the COC before calling for voting. So we should invite the objections. If anybody, we should give a proper time that this claim amount has been admitted. And if you have any queries, then let us know. So ensure all discrepancies are clarified with the creditor before plan approval. Conclusion, claim verification as the keystone of the CIRP. So as we understood that whole the process is depend upon the claims, amount of the claim, because it's not just only the numbers, it is the backbone of the CIRP, and it is the keystone of the CIRP, and they define voting rights of the COC and approval of resolution plan, distribution of the proceeds, and legal stability of the CIRPs depend upon the claims. So thorough claim verification ensures the fairness, transparency in the process, confidence of the stakeholders. It increases because if we thoroughly verify the claim, nobody can question it. If we are doing thorough verification, we should maintain proper records. We should maintain the proper documentation that on what basis we have admitted or rejected or kept in abeyance or whatever we have decided in respect of the claim. So we should maintain the proper documents, and we should maintain a proper report, examination report, when the claims were received, when we can seek the additional documents, when the additional documents provided, when we have intimated about admission of the claim. So we should maintain every database. So thorough claim verifications lead to the smooth approval of the resolution plan without litigation hurdles. We can say that for a resolution professional or a liquidator, claim verification is the single most critical task, and it is the foundation on which the entire CIRP depends. Because claim verification determines the amount determines the voting shares, it determines the security interest, it determines the secured, unsecured interest. So ultimately, it is defining your right to claim in the CD. What Up to what extent a claimant can ask that my dues is up to that amount. So if my dues is 100, then I have to submit the evidence of 100 rupees, and then it is up to the RP or liquidator to verify the claim and to intimate me about the what is the claim admitted. So if you are a operational creditor, if anybody is operational creditor, then he can submit. We have to verify as a RP or as a liquidator. What we have to verify? If he is an operational creditor, we can verify the records available with the information utility. We can verify the contracts which is signed for the purchase and sale of the goods and services. We can verify the invoices provided by the operational creditors. We can verify the orders of the court or any tribunal which is given in relation to that claim. We can verify the ledgers which is provided by the OC and accounts, accounting data, whatever, GSTR returns, purchase orders, any connected documents which can substantiate the debt. In case of the financial creditor, as a RP or liquidator, we can verify the records available with the information utility. There may be some financial contracts like the loan agreements, sanction letters, loan documents, etc. Records of the amount drawn by the borrower, bank statement, financial statements of the corporate debtor, and orders of any court or tribunal which is passed in relation to that claim. Creditors in class, home buyers. So we can check, we can verify these documents like records available with information utility, agreement for sale, letter of allotment, receipts of the payment, such other documents as evidence of the debt, whatever available, whatever is provided in relation to the claim. In case of the workmen and employees, we can verify the proof of employment like contract of service, which is signed between the employer and employee. If he is KMP, then there is a necessary document, evidence of the demands made, or any order of the court or tribunal. Or in case of any other creditor, we can also verify the same, which is related to.
Questions in between?
Yes, yes. You are not audible.
Okay, is it so? Okay, let
So
me log in with.
please speak loudly so that I can hear.
Okay, fine. Can you hear me now?
Yes, yes.
Okay, so I'm saying, is are you in any way assisting in claim verifications? We haven't used that facility. I don't know. Long time back when my assignment started in 2020, that time I could not find any record with IU, and
So,
especially if you're saying for the home buyers claims and all. I just want to understand from the experience of the other participants as well. Is Are you really assisting in claim verification at all?
we can ask the claimant to provide this document, which is available with the information utility, because we have to log in and check whether there is any record of the claimant with respect to his debt. So we can ask from the claimant ki whether if you are having any of these documents, because when any bank is having some dues, then he like file its claim with the information utility NESL and etc. And then they give the record of this default. So on the basis of that, we can verify that yes, this is the claim which is authenticated by the IU itself.
I think so.
Information.
IU must be having a record of only financial institutions or banks only. I doubt for any OC, workman, home buyers, in any other case other than the PFI or banks, it would be useful, because I don't think many people know even about IU how it works.
Yeah, there is a lack of awareness actually. There is a lack of, because
Absolutely.
practically the operational creditor, when he dealing in the goods and services, he is not aware even about the process of the claim. He don't know how to fill the form of the claim, because so many operational creditor come to the office and says that what is the claim form, how
I
to fill
agree.
it, how to
Absolutely.
fill it. They don't know even what is this document and what I need to do about it. Then as a as a RP or I just delegate our team to explain them what is this, what is the procedure in the IBC, and what are the rights covered in the IBC in relation to their claim. So there is a lack of awareness, just because they don't know about the legality and provisions of the law. But when we like ask the additional document, we can mention that you provide me, because they must have some lawyers, they must have some advocates or consultant which they are seeking the assistance in filing of the claims. Because if I will not help in submission of the claims, then anybody must have, or any consultant must assisting them to submit the claim. Then they can do these are the documents which is provided by the RP, and if they can take the assistance from that. Because mostly in the case of the operational creditor, there is a case which is related to the interest. They just put their invoice amount and they just put their interest 18% charged, when as a RP I will verify the claim, I will not accept the interest. Why? Because there is a no contract like financial creditors. Because financial creditor,
Absolutely.
because the financial creditor having their loan agreement, sanction letters, and exact rate of interest, what will be charged, penal interest, but operational creditor simply mention the interest charged on the invoice amount. But as a RP, we can say that if you are having any agreement, if you are having some communication, agreement is necessary between the both the parties in relation to the interest. So if they are having some type, because if there is a big company, like operational criteria is a big company, they must have some record with the IU, because they are like having the good people, good legal team. So they must have some. So there is a provision ki if, like, we are not talking about only 50 lakhs like 50 lakhs amount operational creditor wala. या देर कैन बी सम बिग कंपनीज जिसने करोड़ों का माल अगर कंपनी को सीडी को दिया है, तो दे मस्ट हैव सम लीगल टीम, दे मस्ट हैव द रिकॉर्ड विद आई.
Right. So thank you so much.
या
But in that case, ma'am, how the operational creditor will come in parity with the home buyers and financial creditor?
come in priority. So there,
Parity, not priority, parity. In parity with financial creditors and home buyers, in which in the claims they are charging the interest also, and you are leaving operational creditor without interest in absence of any document.
yes, yes, sir, but we have to do na. We can't admit single one rupees in absence of the documents. We can't
But
like how we can admit the claim in the absence of the documents. I can't admit the claim even single one rupees. We must have, we must see, we must verify, examine the documents which is related to the interest, whatever amount, whatever. Because you simply write, I can write 2 साल पहले के इनवॉइस में मैं अभी इंटरेस्ट मेंशन कर सकती हूँ और वो प्रिंट आउट टेली से निकल जाएगा, एंड यू आर चार्जिंग द इंटरेस्ट. दैट इज नॉट फेयर. You must have some mail communication. You must have some communication
No,
or
but
agreement, which
sometimes that is there in the invoice itself.
no, we will not rely on the invoice that you have mentioned that 18% interest is charged and then now you are. It is not like you have mentioned and you have to substantiate me. You have to satisfy me that how you are charging, on what basis you are charging.
See, when I'm issuing the invoice and the other party is accepting the invoice with the
No
interest
sir,
clause.
invoice is not the acceptable document. Invoice पे केवल operational creditor का sign होता है. It is not signed by another party also ना. It is signed by
It is
one
not an
party.
agreed document. It is
It
not
is
an
not
agreed
the agreed
document,
document.
actually.
It is not the agreed. I can't.
And even in case of home buyer, there is a confusion in the market. See, law says when a home buyer files a claim, there's a provision of 8% interest to be allocated for the home buyers for the, but it also says this allocation has to be done only for the purpose of determining their voting share.
Voting
Now,
share.
there's a lot
Yes.
of confusion whether this amount is part of the admitted claim or it is only for the purpose of the determination of the voting share only. There's a lot of confusion in the market on this point as well.
Because the practice, best practice, matlab, the practice which I adopt or which practice we adopt, that if I am admitting the claim, I must have evidence. If I am admitting your claim, then I must have evidence. You have to substantiate the claim. I must have the document in my custody, which I can prove in the court that yes, this interest is admissible.
No, my
Otherwise, it
question
will,
is that 8% interest allocation, which is provided in the law, is only for the purpose of determining voting share, or it need to be given as admitted amount as well. That's the biggest question. That's a big question actually. And I have,
yes,
as
yes,
consulted many people, very few
yes,
have any clarity
eight
on
No,
that.
no,
percent. Yeah,
this is only for the voting purpose actually.
yeah,
Right,
it
it
is.
should not come
Yeah,
in the admitted claim, but many
no,
people
no.
are showing it in the admitted claim as
No,
well
you will
actually.
admit the claim with interest. That is fine because it is provided in the law actually. So
Okay,
it will
so
be called an
viewers.
admitted claim.
Yes, we can admit there is a no harm. We can admit in admitted claim because there is a provision. Actually, there is a
Yes, yes.
clarification. So then we can admit in admitted claim because there is a proper notification.
Ma'am, I have a small question. May I continue with the
Yes,
question?
yes, please.
Ma'am, you see, the real estate company, the claim is filed, right? Claim is delayed, claim is filed beyond 90 days, right? RP verified it. RP has verification, that means the quality, the claim. Yes, in the corporate debtor books of accounts, claim is shown. That means basically they received the money from the home buyer. This is the one question. Now, this claim, as per the mandate of law, has been placed before the COC because there is a delayed claim. You have to place it before the
Yes,
COC.
regulation 13. Yes.
Right, absolutely. Now, COC rejected it.
On the
Right?
basis of delayed claim.
No, simply rejected. That means we are not going to
Simply.
admit the claim, and they
Okay.
don't say there is no reason has been assigned.
Okay.
Now, my only question is whether the RP should go to the court or some uh,
No, no,
any
no.
any
It's a
aggrieved
regulation.
person.
Yeah, yeah. Regulation 13 says that. See, RP's duty is to place before the COC for its recommendation. And if RP
Absolutely.
is satisfied that and RP is categorizing it as acceptable, collation and acceptable, then he will place before the COC. He will discuss whether it is like we should accept and what treatment we should give in the resolution plan. And if the COC do not agree, then that aggrieved person can go into the court.
But actually,
RP
ma'am,
will
the
not give.
proviso,
RP, if
which
the claim is
which
admitted.
proviso,
Yes.
yes, ma'am, the proviso, kindly just, I think, according to me, I read the proviso also. The provision of the law says the RP should move on an application.
No, it says when it is recommended to the COC and COC
Correct.
says it is
Sir,
acceptable, then only I have to
then
file
Then
as an
only
only,
RP.
then
Suppose the
only,
application
then
for
COC, that
only.
is what
consolidation.
I'm saying.
Otherwise not. Yeah, I'm very
COC
clear. We have done
rejected
that.
it.
Ma'am is right. When you say the COC has rejected the claim, then
Then
ultimately that home buyer has to go to court.
Absolutely. In that case,
we
home
are
buyer
Then
will go.
aggrieved, that means aggrieved and the person has to
You're not
approach the
audible, sir.
oh,
NCLT
you are
for
not
Your voice
audible.
is breaking actually.
admission of
Yes.
their claim.
Sir, we
Yes, yes. Now, am
yes,
I
yes, yes.
am I audible now?
If
Yes,
you
yes.
will read 1C,
Yes,
13, I think this is 13(1)(c), which we are coming into that. We are
coming
coming into
into.
regulation also. So I'm also having some various case laws actually, several case laws in my
Absolutely.
PG. So there is a like it is clear, provision is very clear. There is a and in the 1C. If you will read 1C, there is a B, C, A, B, C, and it is very clear. If it is not accepted, if it is accepted, then RP will give for condonation of delay.
That's right, ma'am. You see, absolutely right. Because the condonation of delay, RP cannot has doesn't have any power to condone the delay. Ultimately,
Yes,
he has to approach. Suppose the
yes,
COC approved it, then you have to move an application as an RP before the court NCLT.
yes, yes,
Suppose
yes,
COC rejected it. Okay, no. Amount is reflected. Rather, reflection is there, but we are rejecting the claim. Now the
yes.
technical problem comes again going to the NCLT. Yes, that is the proviso, but anyway, that takes a huge
Sir,
time to get the.
in my case, matlab not my case, I was like process advisor in that case. That was not real estate case, but the same case happens. You know that NISA Infratech, NISA Agritech, sorry, NISA Agritech and Foods, ठीक है? उसमें ऐसा ही हुआ था कि सर द प्लान अप्रूवल का देयर वाज अ लास्ट स्टेज, देयर वाज अ मीटिंग सीओसी, लास्ट सीओसी मीटिंग फॉर द अप्रूवल ऑफ द प्लान एंड द लिक्विडेशन एक्सेट्रा, एंड देन there was a some RP was placed the claim which is lately filed by the PNB. So the SBI refused that we will not
Correct.
accept this claim, and this is the advanced stage of the CIRP, and then PNB filed a IA in NCLT, and the matters uh, dragged 6 months more, dragged 6 months more, and because of this and ultimately ठीक है, ये तो एक बैंक टू बैंक वाला डिस्प्यूट हुआ पीएनबी और एसबीआई के बीच में, बट अभी
The
उसमें ऐसा
180
था
days over.
मेरे, हाँ ये उस केस में ऐसा था कि अल्टीमेटली लिक्विडेशन का रिजोल्यूशन प्लस पास हुआ तो पीएनबी को डिले करने की जरूरत नहीं थी, पीएनबी लिक्विडेशन में वो क्लेम कर सकता था. ऑब्वियसली यू हैव अ राइट टू
Correct.
आल्सो क्लेम इन द लिक्विडेशन, देन व्हाई यू आर हिंडरिंग द सीआईआरपी, देन व्हाई.
No.
इट्स अ
This is wrong, ma'am. Actually, I am just saying the one thing. It is completely wrong in saying that RP doesn't have any power. The reason being because you verified the claim, collated the claim,
यस
right? Now, one person is goes to the NCLT, gets the order. Another person goes to the NCL, rejected the claim. Then person is remediless. That means he go to the NCLT for their claim. Then he should go to the Supreme Court, till the Supreme Court to admit their claim. Idea is once the claim is reflecting in the books of account, according to me, nobody
then
can
it should
challenge
be
it.
admitted. Yes,
Even
yes,
should
yes,
admit it. That is what
yes.
I'm saying. Technically, it is actually the
But
proviso
actually,
itself is
but
wrong in the saying
but
that
why this provision? You know why? Because it is says that the
delay.
CIRP IBC is a time barred process.
Absolutely. That's the reason. If you're not filing on time, then actually you have to face the
Correct.
consequences for that. That's the
That is
that's
the
that's
that
the
is the
intent of
purpose.
law.
PCI
Ma'am,
is the time-bound
you are
program.
you see, you are giving most of the time we have seen operational creditor, we are giving 1 rupee. In the that is a separate question. Rather, it is not the subject here, I think.
Yes,
But
Hmm.
yes.
however, 1 rupee against the 10,000 claim. I mean, this is a completely until the
It
upheld
is,
by the Supreme Court.
sir,
I
I can't
mean,
explain my
this is
real feelings here.
unjustified.
I can't
Oh,
explain
absolutely.
real feelings. It is before ICSI triple IP. So I can't,
Absolutely. Actually,
yeah. So,
I no
like
problem. Madam, please
we
continue.
know
Thank you.
the like what they feel,
Thank you,
what the
ma'am.
OC feel after the plan approval and
No,
what
no,
they are getting actually.
So,
fortunately now in the home buyer cases, after the Reena judgment and Amit Mehra judgment, now the NCLTs are, not very much declining the cases. They are admitting, they are condoning the delay actually easily.
Yes,
Right.
yes, yes. They
After
of
are,
the
course,
Nehra
there are
case, they are condoning all the delays, and they
Yes,
want
yes,
if
yeah,
yes.
RP is
30%,
verified, they are
This is not a
accepting.
problem now.
30% builders. 30% builders are facing now CBI inquiries. The
yes,
problem is the
yes,
ED
yes, yes,
inquiries.
yes. CBI inquiries, ED
And
inquiries,
there
so
is a
many inquiries.
PIL in Supreme Court
Yes,
against many of the builders. Yes, many cases are pending against the same builders, and RP is being called up. RP has to
yes.
give all the details to the
All the
ED,
details. Yes.
and one after then CBI someone you have to go and join the investigations. These are happening now.
One
That is
more
a
agency
problematic
active,
area.
sir. Nowadays, SFI also active. They also filed an
Yeah.
application 241 before the NCLT.
Then
Now
Under
again,
economic offense
241.
link.
For
Now,
operational
EOW, then
mismanagement.
SHO.
Yeah. For operational mismanagement also
Mismanagement.
now.
You're right.
so now,
Yes.
now they are making you more strong actually.
You see, RPs are, literally, I'm saying I'm from the advocate side in the sense I know many of the RPs are getting notices from the ED departments and the CBI surface, SFS, which you are speaking about,
SFIU, SFIU.
SFIO, and many other government agencies also to join
Till
the
the time,
investigations.
till the time they were summoning us for investigation, we were okay. We were supporting as well. We cooperated as well. But now what has happened?
Ma'am,
One of the case,
But
ED has filed the charge sheet before the
after
thesis
2 years, you're going to
court,
get the
and
summons.
now we are getting summoned to be we have been party to the proceedings of the court also now. Now we have to engage a counsel to appear there
Of
as
course,
well. It was not required at all actually.
this is
yes.
like happening. But
The
actually, what is
problem is after 3 years of the completion, 3 years
yes,
of completion of CIRP, you're getting summons from the government
summons
agency.
from
Then what is the
anybody,
fate? You have to spend
any
your own
authority.
litigation. That is a
Yes, so
problematic area.
Absolutely.
यहाँ पे ऐसा है कि
Yes.
सीडी के सारे पाप जो जितने भी हैं वो सारे आरपी के ऊपर आ रहे हैं, ऐसा हो रहा है। आरपी
अभी तो
आरपी
you have to be
You
more
are
ready
you
because
are you are wearing the
65
gown of
disclosure is
CDs.
coming.
you
Now
are
65 disclosure is also coming.
Absolutely 60.
and I would not
Anyway,
like to
ma'am,
say
please
the
continue. Sorry.
names actually who is giving the notices and all, because there are so much liabilities upon only and upon the RP which he is liable to answer only, because ultimately we are the CD now. So even after we
Absolutely.
exited the office,
Correct.
then also we have not, like, in practical or in real, we are not like,
Yes, yes.
our liability is not extinguished. Our liability is not
No,
extinguished.
ma'am, see,
Only
now this
wrong
is the
things are
order of
happening when you demitted the office.
now this
Absolutely.
is the
Yes,
order of the day, sir. You are handling a company like it was being handled by the promoters. So you have all the responsibilities now.
एंड रेस्पॉन्सिबिलिटी के साथ साथ सर हमें तो ये
Absolutely.
भी नहीं पता कि ये फ्रॉड किस तरीके से किया गया था किस सेंस में किया गया था।
मैम आप अपॉइंटमेंट ले रहे हो तो आपको डीप डिगिंग तो करनी पड़ेगी हर चीज में।
सर वी आर नॉट द
1 रुपए का शेयर
इन्वेस्टिगेटिंग
25
ऑथोरिटी,
रुपए में बेच। Yes.
we have the limited like scope, we have the limited duties, we have the limited powers, वही पूरी नहीं हो पाती है तो then how we can investigate? We are not abide by the investigation, so this should not come to us. This should not come to us because we
No,
are
basic.
not having
where
any
it will go?
powers.
Where it will go then? Who is the
The
person
court
who
interference
for the
is not,
company now?
ma'am. Court
No,
problem is the
agencies usually want forensic report from the audit to be done by the RPs, and that's because we are the custodian of the document. They expect that forensic should be done by us, and then they expect these documents to be submitted. They can't question
it is,
further
So
than that. Beyond that.
it's a presumption. It's
yes,
a presumption that you have
it's
all the
easy to
records
say,
now.
but very difficult to, ma'am. Very difficult to cooperate with criminal agencies,
Yes,
investigating agencies. It's not
and
so easy.
now the law is amending. Now it is coming that the separate agency will handle the CD and RP will do his duty.
Correct.
There is,
Morning
it
10:30,
is
you have to
coming.
join the
It is coming.
investigation.
Yes, it is coming.
Yes,
That
till night you will be there.
yeah, RP will do the limited function, and there will be some separate agency which will like handle the litigation, which will handle the running as a going concern and all. Because as a RP, we have a limited roles, we have a limited duties, we have a limited powers.
That should be understood by the NCLT.
No, ma'am, slight difference. Powers are limited, but duties are not limited.
Yes.
Yes.
It is correct, absolutely.
Please go ahead, ma'am.
That's why now
Please
we
go
are.
ahead, ma'am. Thank you.
Yes, yes. Claim verification for the financial creditors, a comprehensive approach, additional documents. So when a financial creditor submit a claim during the CIRP, the RP must undertake a thorough verification process to ensure the accuracy and fairness. The process typically includes the following steps: the collation of the claim documents, so we have a duty as a RP or liquidator to gather all the documents which is submitted by the creditors. We should cross check with these documents with other books of accounts of the CD and whatever the internal records available, and ensure the claim reflects the correct principal amount and outstanding balance. Verification of the loan agreements and sanction letters, so we can obtain these agreements and sanction letter from the charge forms from the bank or from the records of the CD. So we should examine the original loan agreement to confirm the terms of the lending. We should verify the sanction letters to check the what actually approved loan amount, what was the promoter's contribution therein, because in the loan amount there can be a some amount which will be contributed by the promoters and which will be the non-claimable liability can be, and ensure that the loan is genuine with the contractual agreements, it match with the contractual agreement. We also need to verify the security documents and mortgage deeds. We should check all the security agreements, mortgage deeds, hypothecation, whatever which is attached to the particular loan transaction, and determine whether the claimed security is valid, enforceable. We should cross-check with the every documents correctly recorded. Identify the priority of the security interest if the multiple creditors exist, because there may be a case that one property is one property is charged against the like two, three lenders. So in case of the second lender, he have to obtain the no objection certificate from the first lender. So whether it exists or not, because ultimately it will decide the priority ratio, it will decide your claim ratio, it will affect the distribution of the proceeds. So interest calculations, we should review the calculation of the interest, because we should not rely upon the claim form or the figure which is mentioned on the claim form. We should calculate the interest, including the principal, interest, penal interest, on what basis they have charged. Verify that the interest claimed is as per the terms of the loan agreement. Check for any prepayments or adjustments that may reduce the claims, because if any amount is paid or prepayment is made, then there is a chances of the adjustment, and then it can be reduced. It can reduce the claim amount. Bank statements and repayment details we should ask for, because generally when any claim form C is filed, they don't share all the information. So it's our duty to ask for the like bank statement, repayment details, examine the bank statement of corporate. We have the, obviously, if we have took the handover, then we should must have the bank statement, so we can cross verify the bank statement and transaction records to verify the current outstanding balance, confirm the amount already repaid by the corporate debtor, and we should ensure that there is no discrepancies between the amount claimed and the actual financial transactions. Summary and reporting. Prepare a claim verification report. So we should, as a good practice, we should prepare and keep ready a claim verification report which summarize the principal, interest, and security which is connected with the particular claim. Submit the report to the COC for the review before voting or plan approval, and maintain a complete record. Actually, we should maintain a why we have rejected the claim, why we have admitted the claim, why we have partially admitted the claim. So we should have all the complete record to avoid the future dispute. And if in future, if any dispute will arise with respect to the claim, then we can produce that the basis on what basis we have actually did this. Delivery and purchase verification. So in case of operational creditor, verify the delivery of the goods or completion of the services through the delivery challans, acknowledgements, receipts. We can call for the documents if he is not provided. Match the claims with the purchase orders or contracts to confirm the legitimacy of the claims, reconciliation and final assessment. So we have a duty to reconcile the claimed amount with any partial payment already made, check for any disputed amounts or adjustments, prepare a summary of the verified claim. So we should like claim verification is a very important step. So I would suggest to we should have the summary. We should have the like proper basis. We should have the documents of the basis of the claim. Why, on what basis we have rejected, admitted, partially rejected, and how we determine the security interest and etc. Reporting and documentation. Maintain a clear record of all verification of the admission or rejection of the claim. Prepare a claim verification report for the COC review. Ensure the transparency and accuracy to avoid the disputes and litigation later. Related party. Yes, in my case, it was happened that I was feeling that it is a related party transaction, then, but I don't have any books of accounts which is not given and provided by the management of the corporate debtor. Then I asked for related party disclosure affidavit and I shared my affidavit format of the related party disclosure affidavit, and I have taken the affidavit from the claimants to determine whether they are the related party claims or not. So if in case it may be applicable in your case, so then you can do like that. Interest claimed by the operational creditors, like if anyone, like this is my practice, that if any operational creditor just mention the interest and add with the invoice amount, then I don't accept without any supporting documents. Interest claimed by the operational creditor, this is the key point. So no agreement, no interest. Under the IBC, an operational creditor claim only the principal amount of the unpaid operational days unless there is a contractual agreement for the interest. In the absence of any express agreement or clause between the parties agreeing to pay the interest portion cannot be admitted as a part of the operational debt. NCLT on the interest without agreement. The NCLT has held that interest cannot be
Ma'am,
claimed or yes,
ma'am, can I ask a question, ma'am?
yes.
Ma'am, ma'am, in case a bill is raised by the OC and the company, I mean, accepts the bill without any objection, over which, I mean, the interest, I mean, clause at the rate of say 18% or 24% is mentioned, then bill is an agreement, ma'am. So in that case, what will be the I mean, course of action?
Means you want to say that the rate of interest is mentioned on the bill.
Yes, ma'am.
Bill means
And,
invoice.
yes, ma'am. And the invoice is accepted by the company, raising no objection. So
No.
in that case, what
Yes,
will be the
yeah.
what will be the course of action, ma'am?
So invoice is not an agreement which require the offer and acceptance. So agreement means as per the law, offer and acceptance must be there as per the Contract Act. So invoice and bill cannot be said an agreement or a mutual consent to pay the interest. So in my view, invoice or bill is not automatically means that it is an acceptance of interest as well as with the amount of invoice. So if you are having any separate contractual agreement or any mail communication with respect to only interest portion, then I can say and I can admit your claim with interest.
Okay, ma'am.
Yes.
That means, ma'am, only if it is mentioned in the purchase order, then then only the factor will be taken into consideration.
We will not take into consideration.
No, ma'am.
It is
If the interest is mentioned in the purchase order, ma'am.
Okay, in the purchase order, and you are accepting it if
Yeah, ma'am. Yes, ma'am. Then
by
in
written
that case only,
confirmation.
Then in that
By
case only it will be taken into
yes.
account. Okay, ma'am. Thanks, ma'am.
So we was on NCLT on interest without agreement. The NCLT has held that interest cannot be claimed on operational debt unless there is an express provision in the contract or agreement for interest. Simply inserting an interest clause in the invoice without a contract accepted by both the parties does not create any binding liability to pay the interest. Operational debt definition excludes the interest without agreement. 521 of the code defines the operational debt as a dues arising from the supply of the goods or services. Interest is not included in this definition unless it is payable under an agreement. The interpretation reinforced that interest claimed without an agreement cannot be treated as an operational debt under the IBC. Invoice alone do not create the interest liability. Court have ruled that an invoice within a boilerplate standard clause or unilateral interest clause not agreed and signed by both the parties, it is not enforceable as an interest in the IBC proceeding. Interest claimed solely based on the unilateral clause cannot support Section 9 applications even. PF claims verification, what we can verify as a RP in case we receive the claims from the PF department. So generally there is a standard checklist. Liability under the EPF Act, ensure the PF dues relates to the actual employer's statutory obligation before the CIRP start. We can verify the PF assessment orders, notices, which they provide with the claim. They generally do not provide the claim form. They are like king, why we will provide the claim form. They just mention that this amount is due. Supporting documents, we can call the demand or assessment notices by the EPFO, pay slips, PF contribution records for the employees, EPF passbooks or contribution statement showing the employer and employee contribution. employer's records to confirm deductions and non-remittance of the PF amounts. We can cross-check with our books of accounts of the CD. We can reconcile the PF amount claimed with the CD's books of accounts and employer's PF remittance records. And in case law, CA Pankaj Shah versus EPFO, NCLT held that any PF claim arising from the inspection and assessment orders issued after the commencement of the CIRP cannot be admitted because such liability is created during the moratorium period and it is barred under Section 40. So if they issue any order, then after the commencement of the CIRP, we will not entertain. So these are the answers given by the IBBI for the questions which is raised by the insolvency professionals. In the absence of the books of accounts, it is difficult for the RP to admit the claim and constitute the COC. How should the RP proceed in such case? Then IBBI replied that the RP should consider the documents and annexure which is submitted by claimant. He may also obtain the list of the creditors or the related information from the NESL and the applicant creditor if available. He must also use the available information such as a bank account, means available information हमें use करनी है, such as a bank account detail record, such as MCA record, charge record, income tax, GST record, PF record, and to admit the claim. Thereafter, RP must update the information as and when received. So we will update when we will receive. If the claim under caution is the subject matter of the litigation of the CD, how is the RP or RP required to deal with such claim? If the claim under the caution is the subject matter of the litigation, all the claims which are the subject matter of the litigations of the CD should be disclosed in the information memorandum. The RP should act as per the regulation 14(1), which provides that where the amount claimed by the creditor is not precise due to any contingency or any reason, the IRP or the RP, as the case may be, shall make the best estimate of the amount of the claim based on the information available with him. If there is a litigation before the NCLT on the claim admitted or rejected or partly admitted or rejected, how the IRP should deal with such? The treatment given to such claim by the IP shall continue till the outcome of the decision before the adjudicating authority. In case of an interim order by any court or judicial authority, IP has to act accordingly. If any creditor having the balance in the CD books does not submit the claim, in spite, IRP or RP having sent email letter to the creditor whether the same to be admitted, the IRP should act as per the regulation 6A, which provides that IRP should send a communication with the public announcement to all the creditors named in the latest books via the post or email. The IP should endeavor to receive and collect as many claims as possible by sending the individual communication to all the known creditors. In a real estate case, IP must send the individual communications to all the known home buyers. However, if any creditor having the balance in the CD books and does not submit the claim, in spite RP having the mail, and then the same should be stated in the IM for the knowledge of PRI. Because at any stage he can walk up and come, please submit and please admit my claim. So we should disclose the IM that it is a open-ended claim. It is not claimed and admitted, but it is open-ended claim which is showing in the books of accounts. If the books are not updated and the claim is submitted along with the sufficient supporting documents, can the RP accept the same even though the same is not matching with our books? If the books are not updated and the claim is submitted with the sufficient supporting documents, the IRP can accept the claim. IRP can submit the claim. However, the supporting document should provide the adequate proof of validity of the claim. IP should also make an effort to reconcile, revise, and updation of the books of accounts after taking into consideration. So we should update the books of accounts accordingly. Banks are charging penal interest, default interest as per their card rate, which is sometimes very unreasonable and high, say more than 20 PCT. Should IRP, RP percentage, 20%. Should IRP, RP consider such high rate of interest while verifying the claims? Financial institutions such as a bank as defined under the code are regulated entities. Hence, the interest and other charges charged by such institutions as per the applicable loan document should be included in the claims. However, for unregulated financial or operational creditors, the RP may examine the transactions from the perspective of the extortionate transaction. If the PF department does not submit their claim as per the process or format, despite instruction, the claim can be rejected. As per the judicial pronouncements, creditors, including the EPFO, can file their claims other than, because there is a judicial pronouncement. So they can file other than in the prescribed format with the supporting verifiable documents, and IP should consider the same. IP should not reject the claims merely on the technical grounds. So these are the
I think
common.
this claim, this judgment of claim is specifically for IPFO, or I think there is even more judgment that any creditor filing a claim, just because his claim form is not correct, I think RP has to, verify and admit. It's not only for the IPFO, I guess so.
The EPFO में particular case laws हैं that it is not RP cannot deny to admit the
I know,
claim.
but I have heard the similar judgments are probably from NCLT or NCLAT. It might not be for Supreme Court, but I think in other cases also there are some judgments that just because of the wrong form selected by the creditor
Yes,
is
yes,
not the criteria to
yes,
reject.
yes.
Otherwise, also
There is that case law also. Both.
absolutely,
Yes, yes. The case law, we are coming to that. I am coming to
okay,
that on
okay.
because
No, after Sony judgment, actually claim form is not relevant. Actually.
yes,
Right.
there are the case laws where in one case wrong form has been submitted and the RP rejected. Then it was decided that you cannot reject the claim on the basis of the wrong form has been submitted by the claim.
Right, right. So claim form is not a criteria these days now.
Because ultimately we have to determine the liability actually.
Absolutely. They have become claim form has become recommendatory in nature now.
We can raise the query to the
Right,
claimant that you please correct this query or deficiency, but we are admitting the claim. बट हम तो
right.
ऐसे डिस्क्लोजर के साथ कि सब्जेक्ट टू कि आपने ये एक वीक के अंदर कर दिया तो देन मतलब वी आर लाइक वेटिंग फॉर वी आर गिविंग यू द टाइम टू रिजोल्व दिस क्वेरी और इन केस ऑफ एनी फ्यूचर लिटिगेशन देन इट मे अराइज ऐसा करके हम एक मेल कर देते हैं तो क्या है कि हमारा भी सेफ्टी रहेगी हाँ हमने भी कोई एक्शन लिया था बिकॉज आरबी के ऊपर तो फिर ऐसा है कि वी हैव टू डू आवर ड्यूटीज कि आपने कैसे उसको वापस से क्वेरी रेज नहीं किया यू हैव नॉट करेक्टेड द प्रोसीजर बिकॉज प्रोसीजरल पार्ट पे भी हमें चलना है स्ट्रेटेजी पार्ट पे भी
Right,
हमें चलना है लीगल
right.
पार्ट पे भी हमें चलना है इसलिए दैट्स व्हाई so there are the common mistakes we found when the at the time of the verification of the claim, like not submitting the prescribed form, incomplete filing of the forms, incorrect or errors in the forms, insufficient supporting documents in the claim, no proper breakup of the principal interest damages. We have to ask sometimes कि please give the breakup in the Excel sheet or what are like if कभी कभी 500 invoices होते हैं उनके तो like they like combinedly they charge mention like this so and so amount is pending so it should we have to ask the Excel file so please give the breakup of all invoice amount what is the invoice amount what is the whatever you have charged so accordingly we will verify there may be error in calculations, not sending claims to the correct address of the liquidator, not proper signing, notaries, stampings of the documents, non-disclosure of the complete and relevant details which is required in the claim form, how the, like they don't clearly mention how the debt is arised. So we have, for the verification purpose, we need that information. Claim amount till the, yes. They sometimes include the amount till the date when they are submitting the claim. So we have to correct it because they can claim up to only as on the ICD. They cannot go beyond that. So when we like interact with the claimants, then we can give the tips to the claimants for the submission of the claims. We can advise them. Yeah, our team can advise them. Or generally, we send the communication. When we send the communication, we attach the claim form Word file. So choose the correct claim form and fill it completely and correctly. Arrange the documents with the proper chronology. So what is what is needed exactly? What affidavit and declaration is to be given and which is to be submitted, signed and notarized copy along with KYC documents. It should be there. Proper communication details should be there because bank details and amounts and security interest, which is mandatory. And send the physical as well as email scanned copy of the claim form. Create the email trail. Yes, take the professional expert guidance for the calculations, detailed working if we can do that or we cannot, depend upon situation. File within the prescribed time and respond also submit the clarifications for the requirements asked by the RP. So we can advise these points. Effective process for the IRP or RP in handling the claims. So we can set up this procedure for the effectively processing and handling of the claims. Like we can set up self-generated acknowledgement or auto reply. When we receive the claim, then we can generate a auto reply that we have received, we have acknowledged your claim, and we will verify and will update you about the admission or rejection of the claim. Claim forms along with the documents to be properly segregated according to the type of the claim. Physical data we can convert into soft copies for to maintain the records. Maintaining the confidentiality of the data and documents and all the folders and files must be password protected and logged. Type or punch in the maximum details in the Excel sheet for the quick access. This is for proper folder management with the chronology and sequence. Yes, so that we can find out in the letter after the 1 month, after 2 months, after 3 months. If we need some data, then it should be like that. Quick action on all the claims, saving the data, verification and communication, proper method to store, save the data with the effective backup system we should have in the office. We can also like structuring the database in the Excel quick access के लिए. We can maintain like this serial number, date of the receipt of the claim, what is the full name, claimant's address, claimant's email address, claimant's mobile number, type of claimants, mode of submission, name of authorized representatives, residential address, whether the form is correctly filed, list of enclosures he submitted, list of enclosures he's not submitted, relationship with the corporate debtor, yes or no, nature of relationship, whether assignee to the claim or assigner, whatever. So this we can for the quick access, like we need not to go through the claim form if we will maintain like this in the Excel. We can mention the principal amount. We should bifurcate and we should maintain this in Excel so that it will be easy to for the quick access and quick review. But principal amount, interest, penalties, or other charges, whether security interest created, particulars of the security interest means what is covered, what is not covered. The detailed, we can also mention that first charge या second charge है कौन सा है. Detailed calculation of amount, details of the payment, details of disputed amount. And yes, we also mentioned what is the amount payable under as per the series record. फिर then amount under verification कितना रखा है, amount reject कितना किया है, voting percentage क्या है, and remarks etc. And then bank details भी हम maintain करके रख सकते हैं, name of the bank because at the time of distribution it will be useful. Name of the bank branch, name of account holder, account number, IFC and all. Yes, though this data correspondence is what we have done with the claimants. We can also maintain these records in the Excel. Date of submission of claim, date and time of receipt of the claim. Sometimes we receive the hard copy late. So we should also like mention on the hard copy that this date we have received the hard copy. Subsequent communication details like trail of the emails we can maintain in the Excel file. Timely provided for the reply, date of subsequent reply, further requirement asked, claim disputed or non-disputed remarks so that it will be very easy to verify any claim.
Ma'am,
Yes.
ma'am, if the if the
Yes.
company has has extended any bank guarantee, to any supplier, and I mean that supplier's loan, liability happens to be, it's okay in the books of the company, but the company has been under CIRP due to default. It has committed to the financial creditors. Then in that case, what will be the treatment of the bank guarantee, ma'am?
Means corporate debtor has taken any loan and
Actually, ma'am, it's not loan. Say, supposingly, there is a BG which is covering the credit period of the operational creditors, and that BG has been given to the OC as on the date of the ICD. What will be the treatment of that BG? will that be left as it is, or it will be also taken in the form of a claim?
So if bank guarantee means bank guarantee is given to the operational.
Operational creditors, like, I mean covering the, credit liabilities of the of the OC. Say वो OC अगर
So
3 महीने
in that
का,
case, so
हाँ,
bank guarantee is given to the CD, na?
मैम अगर अगर सीडी कोई बिजी देगा ओसी को, ओसी का जो उधारी है उसका अगेंस्ट पे, तो अगर अगर
Madam,
अगर
can I say?
What you
Can
are
I
Yes,
say
asking
what he's
actually,
trying to say? I can explain what he's trying to say. He's saying that a bank guarantee has been
so your
given.
voice is not audible actually.
Oh, okay, fine. Then let him conclude.
मैम, can I once again explain? I mean,
Yes. थोड़ा सा सर लाउडली बोलिए ना सर, थोड़ा वॉइस का इशू है.
अच्छा, ठीक है. Actually, ma'am, say, I mean, if a company issues a bank guarantee to any operational creditors as against the credit which is getting availed by that the company from the OC. Say the company is availing 3 months credit, okay, and that bank guarantee is covering that. I mean, credit. I mean that credit liability. Say that the company has been into CIRP. So as on the ICD, ma'am, what will be the treatment of that BG? Will that be taken by the RP as a claim? That is my question, sir. The
Yeah,
question, ma'am.
that is what is mentioned in the agreement.
Sir, I think it's a contingent
Actually,
claim.
in
It's a contingent claim, sir.
What is the
In
line?
the
What is mentioned in agreement actually? What is mentioned in agreement? It is depend. You have if you, whether you have clarified your liabilities that in that case it will happen, then he can claim from this and so and so.
actually,
It is
ma'am,
depend upon the document we
bank
have
guarantee
to
का
read
तो,
and verify. It is depend upon the document we read and verify.
अच्छा,
Because
बैंक
it is a
गारंटी तो
third
जब होगा
party.
इन्वोक. Yes, ma'am. अच्छा.
Because it is a third
I mean, I
party.
mean, तो तो उसका ट्रीटमेंट कुछ भी नहीं होगा as on the ICD. That will
Because
be, I mean, left as it is, as you are telling.
we have to verify. If anyone submit the claim, then we have to verify on what terms the guarantee was given. On what term? Because there may be some language, there may be some clause which can substantiate or which may affect my decision. I can't say simply on this question ki I will accept, I will not accept, or this treatment is available actually. I need to see the document for that.
See, in this cases, guarantee is a security only. There can be a secured operational creditor, there can be unsecured operational creditor. So he can be
Yes.
treated as a secured operational creditor. That's all.
Yeah,
If
but
there is
because
any liability, if the claim is there, then he can be treated as a secured operational creditor.
we have to check the documents as well also.
Yes, based on the documents only. Once
Yes.
the claim is admitted, then he can be considered as a secured operational creditor. Thank you.
Okay, ठीक है. Okay, ma'am.
Situations when the claims to be submitted. So in the CIRP, there are some regulations. Regulation 7, claim submitted by the operational creditor. Regulation 8, claim submitted by the financial creditors. Claim by the creditors in the class. Workmen and employees, claims by other creditors, substantiation of the claims. Regulation 11, cost of proof. So we are going, this is this procedure is also in the liquidation process. Regulation 16, submission of the claims. Regulation 17, OC, FC, workmen, employees, other stakeholders, substantiation of the claim, determination of claims. So these are the, in the pre-packaged also, personal guarantors also, in the bankruptcy also. So there is, there in all these cases, in all the regulation, different stage, we can, claimants can file the claim. There are the different forms for filing the claims. Form B, like in the CIRP, there is a different form. In the liquidation, there is a different form. So in the CIRP, there is a Form B for the OC, Form C for the FC, Form CA for the class of creditor, Form D for a workman and employees, and Form E for the authorized representative of the workman and employee, and Form F is proof of claim by the creditors other than FC and OC.
Ma'am,
Yes.
as per new amendments of 26, all the claims to be verified at the CRP by RP, not by the liquidators.
Yes,
Okay. Only
yes.
after the claims which is not verified by
Yes,
the
yes. There is
RP,
amendment.
only that is
There,
liability.
yes. There is amendment that all the claims will be verified by the RP.
That means if liquidation is commenced later stage, the
Yes,
claimants whose claims are already verified and admitted at the time of CRP,
will not be verified.
they don't need to file it again.
Yes, there is amendment.
But now in that case, if I'm filing a fresh claim in liquidation, and
Then
I
we
have not
need to
filed it,
verify.
but in that case, मैं इंटरेस्ट कब तक का चार्ज करूंगा उसमें? अगर मैं अगर इंटरेस्ट चार्ज करता हूँ तो मैं कहाँ तक का चार्ज करूंगा? डेट ऑफ कमेंसमेंट ऑफ CRP और लिक्विडेशन?
Date of CRP, sir. That is
Actually, I
date of
need
CRP.
to.
Not yet
No, no.
that is on the date of CRP only. Not LCD has not been communicated. That is the date of LCD for
From the
calculation.
yeah.
That is on the date of CRP. It has
Yes.
been,
To the
that is
because
on
after the moratorium, you cannot increase your claim now.
right. But previously it was date of LCD.
Now
You
we
Yes.
have an amendment only with regard to that RP will verify the claim and there will be no updation in the claim. And now
Yes.
I'm filing a fresh claim. This is my question.
Just a minute.
So it will be only up to the CIRP. It is mentioned in the
Yeah,
amendment.
logically, it should be up to CRP date because everyone
Yeah,
else
it is
has
mentioned in
filed the
the
claim till CRP date, man.
Yeah, as per the readings of the law, as per the reading of the law, we can say that it should be up to the commencement of the CIRP.
Right.
As
Ma'am,
per the
even if it
reading.
is even it is as per the I mean the amendment that has taken place,
Yes.
it is only as on the ICD.
Yes.
Checking part has been reduced, shortened. That's why total liquidity period has been shortened by the only in respect of 1 year. That only but 60 to 160 days has been given. The liquidity period also be shortened accordingly.
The liquidity, sorry, sir. The liquidity?
Previously, the liquidation period that was the maximum 1 year.
Yes.
Now it has been reduced.
Yes.
Because the limitation checking period has been completely shifted to CRP by RP. That's
Yes,
what
180 days now.
that is only 6 months.
Yes.
And I have one more question. In many cases, especially in home buyer cases, this has happened that, a home buyer is claiming, say example, only 5 lakh rupees, but while RP is doing verification, he comes to know that as per the books, the amount paid by the person was 15 lakh rupees, more than what he has claimed. So in such cases, can RP admit more than what has been claimed, or he should intimate to the claimant
Intimate.
divide?
Not
That
shoe
means-
moto. Not
That
shoe
means
moto.
we cannot admit more than the claimed amount because there is no way it is mentioned in the law that we
Yes.
cannot admit more than the claimed amount.
We
So
can
if-
intimate. We can intimate and confirm. Because sometimes होगा क्या? अभी वो 5 लाख का क्लेम कर रहा है. Later on he will walk up कि मैं तो भूल गया था 10 लाख का क्लेम करना. So we have a duty to intimate because in the some case laws there is a quote mentioned that you have a duty to intimate because in future it may arise the dispute.
Okay. And there
But
was
what
one more
if
case where the claim was verified. So sorry, I just have one more connected question. That in one of the cases, the claim was verified. Later on, RP, got to know, it came to his notice that there was a check bouncing case also, and this check got bounced later stage. The claimant filed everything along with the bank statement, everything with the RP basis that the claim was verified. Later, RP got some access to the additional material record of the corporate data. He comes to know that one of the check got bounced. So can he decrease the amount already admitted by the
He
RP?
can
Is it
increase or he can decrease, he can update the claim. There is a regulation. When RP comes across any additional information, then he may update the claim. There is a regulation.
if the home buyer has not charged any interest in his claim, can the RP add the interest to motor?
Sorry,
8% is there in the law? I think that
Yeah.
8% mandatory which is
Related to interest, there is
So RP can add the interest.
Yes.
Suo moto.
Yes.
It is mandatory for determining voting share. That was my first.
Right.
Ma'am, just tell me the regulation where it says the RP can, decrease
Yes.
even the claim. No,
I
but
can speak. Yes. I have to do Control F in my PDF. One second.
or you can continue. We can take up at the end also. I don't want to
Yes.
interrupt it.
No, it is mentioned that when regulation 15, I think regulation 14 or 15, because I have mentioned in my some case. Yeah. 14.2, regulation 14.2.
Okay.
The IRP or the RP, as the case may be, shall revise the amount of the claims admitted, including the estimates of the claims, as soon as may be practicable when he came across any additional information which warranting such revision.
Okay. Revision can be anyway. Revision means increase or
Obviously,
it covers
there is
both.
not mentioned that it will be
Right.
upward.
Understood.
Yes.
Okay. Thank you so much.
Yes. Regulation 6 is related to this public announcement. So when the insolvency professional makes the public announcement immediately on his appointment on an IRP, in Form A of the Schedule 1, one English and one regional language newspaper with the wide circulation of the location at the registered office and the principal office when the corporator conduct the material business operations. And the public announcement to be placed on the website. If it is not, obviously, in very much cases, there is no website which is maintained by the corporator, then we generally make a URL.
This is another confusion for regional language newspaper. What people are doing is they are using that language newspaper, but the publication has to be done in that language or English only. That is the biggest confusion. Many times people say the newspaper has to be a regional language. The publication can be in English in that newspaper also. So I think there is no clarity on that, whether the language has to be vernacular language of that
It
level
is,
or newspaper.
it is IBBI given the freedom to the IPs. IBBI given the freedom कि how you interpret it is up to you. मुझे अगर मराठी में देना है तो I don't understand मराठी तो how I will verify the content of in Marathi.
That's why they should not say
No,
regional language.
ma'am.
Also, the
If the
language should
Hindi
be the
newspaper,
regional.
if Hindi newspaper is there, then you have to give it in Hindi only.
No.
No,
If
what many RPs and many professionals are doing, they publish in the Hindi and English newspaper, but the publication, the matter is in English only, and this is happening
No,
for the
ma'am. That should not be there. It
So
should be in the language of the region actually.
Right, the language has to be regional, but I have seen, if you will go with many newspapers, you will find regional language newspaper also having the publication in English only. People are using the newspaper of regional language, but the publications are in English only. This I have
that
seen
is incorrect actually. Then the purpose is defeated.
Absolutely.
सर बहुत सारे केसेस में ऐसा अभी रिसेंटली मतलब ठीक है वो सबका अपना
प्रैक्टिस के लिए हम कर रहे हैं सारे कर रहे हैं प्रैक्टिस के लिए लाइक फाइनेंशियल एक्ट्स जनसत्ता नॉर्थ में ठीक है दोनों में इंग्लिश में दे दिया फाइन
ये एक्चुअली अभी तमिल है मुझे तमिलनाडु में के न्यूज़पेपर में रीजनल न्यूज़पेपर में देना तो हाउ आई विल वेरीफाई द तमिल लैंग्वेज
मैम योर पब्लिशर विल कन्वर्ट इट इनटू तमिल लैंग्वेज
IBBI will not understand if
no,
you
IBBI leave IBBI but
if you
it is very
I am giving you very practical example and live example मतलब कि you know and IBBI know and you and we know I don't understand Tamil but if any mistake happens in the public announcement IP will be responsible.
We have to rely on the professionals in
You
that.
are misleading the public. You are misleading the public. IBBI will ask the question.
How IBBI will understand Telugu?
Sorry?
How IBBI will understand? Do they have professionals? Do they have all language? No, I think the clarity should be in the
translators are there. See, no.
Translators are there. Tamil, madam.
Yes. If the case is in Tamil Nadu, then IP will also come to Tamil Nadu.
I think
Anyway,
they
that's a
should.
separate thing.
Well, bench has been divided according to the region.
Yes.
I
नहीं
think
नहीं नहीं देखिए हम लोग क्या करते हैं मैम मनीषा मैम देखिए हम लोग क्या करते हैं अगर मान लीजिए कि रीजनल लैंग्वेज में है सी एज मैम सेड कि मराठी में है ठीक है हमने अपने जो पब्लिशिंग एजेंट है उसको बोल दिया कि भैया मैं कन्वर्ट करके देना है मराठी में वो कन्वर्ट करके पब्लिश कराता है
सर हम भी ये कराते हैं, बट व्हाट आई एम सेइंग इज कि इन द लॉ इट शुड बी वेरी क्लियरली पब्लिश दैट
It is not mentioned.
and in vernacular language also they should
Yes.
clearly mention, because the practice is going on. Even I am getting it translated by the newspaper agency only, they do that. But I have seen such cases also, so that's why just to avoid, just to mitigate that ambiguity, I think the law should very clearly say in one regional language newspaper in the vernacular language. It would be very simple for everyone to understand. Why have
मैम
they given the or
दैट इज व्हाई दे आर फोकसिंग ऑन द लोकेशन ऑफ द रजिस्टर्ड ऑफिस
Yes. Yes. And if you will see in Companies Act,
Oh, they are saying one regional language newspaper with wide circulation in the registered office. That is perfectly fine, but they haven't
they
mentioned
हाँ
the
हाँ
language in
ये
which it has to publish. न्यूज़पेपर सिलेक्शन तो हम तमिल का ही कर रहे हैं या हम कन्नड़ ही कर रहे हैं, लेकिन
हाँ
छाप तो उसमें इंग्लिश में ही रहे हैं ना कई लोग.
so there is a no mean. There is a no mean actually and practically though, but interpretation is not clear by law itself. Interpretation is not clear by
They
law
should
itself.
mention in the regional newspaper
Yes.
paper in vernacular language also. It should be mentioned. I think in Companies Act they have mentioned like
They
this
have
in many
mentioned in
sections.
Companies Act, they have
I
mentioned
think
very
it is.
clearly.
Absolutely. In IBBI regulation, this clarity is missing actually.
Yes, this clarity is
नहीं,
missing, and IBI
you will
cannot.
actually fulfill the requirement when they say one English newspaper means in English and the other in regional language. It should be in the regional language also.
हेलो हाँ हाँ आप आओ ना हेलो हाँ ऊपर आ रहे हो ना हाँ हाँ ठीक है ठीक है
Okay, I think we can continue. So
Yes.
this is the ambiguity in the law actually. They should clarify.
Can I take a break of one minute, just 1 minute?
Yeah.
We can, sorry for, hold on. So can we continue?
Yes, ma'am.
Yeah.
Yes, ma'am.
So there is a like clarity, and gradually IBPI will clear the provisions, and will make some understandable and clear provisions so that we can act accordingly. And I was on this like public announcement to be placed on the website of the corporate debtor, if any, and of the board पे तो हम करते ही हैं, but generally CD की website होती नहीं है, तो generally we create a URL, just as a URL on which we publish the NCLT order, we publish the copy of public announcement, we publish the details about the CD, so that any PRA when visit the, like, there is no websites, and if we want to take some like brief about the CD, then we publish on the URL so that he can see what is about the CD. We place some pictures, we place some videos, we place the video of the assets available, what is the present condition of the CD, we just place on that URL so that the PRA can visit that. And because you know that URL has to be mentioned in the form G, so in form G we also place that URL also for the information of PRA. Public announcement to state where the claim forms can be downloaded or obtained from. Offer choice of the three insolvency professional. Provide the last date of the public announcement का content है ये. ठीक है, next. Communication to creditors. Regulation 6A. The IRP shall send a communication along with a copy of the public announcement made under Regulation 6 to all the creditors as per the latest. So we have a duty, if we like verify and go through the balance sheet, and if we can see that there are this number of the creditor, we can see it. If it is appearing in the like in the notes to in the balance sheet, in the balance sheet, or in the like notes to accounts, or wherever we can find the names of the creditors, then we should email them, or we should, if email is not available, if address is available, then we should send a hard copy, and we should invite the claims specifically. Post or electronic means, we should like intimate them. Provided that where it is not possible to send a communication, then the public announcement made shall be deemed to be communicated to such creditor. अब यहाँ पे shall आ रहा है. Regulation 6A is talking about the shall. तो शेल मीन्स इट इज मैंडेटरी. अभी आईबीबीआई हमें बोलता है कि आपने ये नहीं किया तो इट विल बी द, उनकी नजरों में ये भी एक वायोलेशन हो जाएगा. Regulation 7, claims by the operational creditor. Regulation 7(1), a person claiming to be an operational creditor other than the workman and employee to submit the claim with the proof to the IRP Form B, Schedule 1, submission in post or by the electronic means. Person may submit the supplementary documents, clarifications, and the support of the claim before the COC. Claims by the OC. The existence of the debt due to the OC under these regulations may be proved on the basis of the records available with the IU, other relevant documents, a contract for the supply of the goods or services, an invoice demanding the payment for the goods and services, an order of the court or the tribunal, and financial accounts. So we can, like, when we raise the query, yeah, when we seek the additional document, we mention everything, whether you are having or not. You just give me reply. I have a right to ask everything as a RP. The existence of the debt due to the OC under this regulation may be proved on the basis of the copies of the GSTR1, GSTR3B filed under the provisions of the relevant laws relating to the GST, and copy of the e-way bills wherever applicable. So we just ask everything. You are having or not, it's your problem. You give the answer, you solve the query. On the basis of the document submitted, we will verify the claim. Claims by financial creditor in the Form C in the electronic form may submit the supplementary documents and clarification in support of the claim before the COC. Regulation 8(2), the existence of the debt which may be proved on the basis of the records available with the IU, other relevant documents, including the financial contract supported by the financial statements. We can, like, financial contracts, it is the main document, financial contract, like the loan agreement, section letters. Record evidence that the amount committed by the financial creditor to the corporate debtor under a facility has been drawn by the CD. Financial statement showing that the debt has not been paid. The order of the court or tribunal that has been adjudicated upon the non-payment of a debt by a class of creditor. So these are the documents through which he can substantiate the claim. The records available with the IU, the other relevant document, agreement for sale, letter of allotment, receipt of payment, or any other document evidencing existence of the debt. Regulation 83 by in a class like home buyers की class या FD holders की class, कुछ भी class हो सकती है. Claims by the workmen and employees. A person claiming to be a workman or employee of the corporate debtor shall submit claim with proof to the IRP in person by the post or electronic means in the Form D, where there are the dues to the numerous workmen or employees of the corporate debtor or an authorized representative may submit the one claim in, like it is generally happen. When there is a numerous workmen and employee, then one person submit the claim in the Form E. So these are the documents which may be submitted in the support of the claim, and we may ask this as per this provision. Claim verification, claims by the workers and employees, then we can verify the employment records, wages and salary registers, attendance sheets, PF, ESI statement. This is very clerical work. HR approval records, contracts, engagement letters, standing orders or code of conduct. Unregistered informal labor claim verification relies on the industrial norms, muster rolls or HR affidavits. So we have to deep dive into labor law. This is about labor laws. Gratuity Act, Bonus Act, everything covered into this. ESI Act, PF Act, everything. Industrial Dispute Act, Factories Act. We have to verify everything. What they are getting, and how much attended and all. Like on that basis, we can verify. Claims by other creditors. A person claiming to be a creditor other than those covered under Regulation 7, 8, 8A, 9 shall submit the claim, its claim with the proof to the IRP or the RP in person by the post or electronic means in the Form F of the Schedule 1. Like a guarantor may submit the claim into this. Claims by other creditor. Because he is not falling in the operational, in the financial, he is just a guarantor, then he can file this claim. This existence of the claim of the creditor may be proved on the basis of the records available with the information utility, other relevant documents, which is having like guarantee agreement and all, documentary evidence, bank statements, order of court. Regulation 12, substantiation of the claims and post. Regulation 10, the IRP or the RP as the case may be, obviously, we have to do this, may call or such other evidences or clarifications as he deemed fit from a creditor for substantiating the whole or part of its claim. Regulation 11, cost of proof. Creditor shall bear the cost of proving the debt due to such creditors. Submission of proof of claim. Regulation 12. A creditor shall submit the claim with the proof on or before the last date mentioned in the public announcement, provided that a creditor who fails to submit the claim with the proof within the time stipulated in the public announcement may submit his claim with proof to the IRP or the RP up to the, when अगर उसने like 14 days के अंदर नहीं किया है, तो then he can up to the issue of the RFRP, date of issue of RFRP under Regulation 36B, or 90 days from the ICD, whichever is later. Provided that the creditor shall provide the reason for the delay. We have to ask the reason. He will not provide the reason. Reason for delay in submitting the claim beyond the period of the 90 days from the ICD. Where the creditor is a financial creditor under Regulation 8, it shall included in the committee from the date of admission of such claim, provided that such inclusion shall not affect the validity of decision taken prior to such inclusion. Regulation 12A, updation of claim. Regulation 12A, a creditor shall update its claim as and when the claim is satisfied, partly or fully, from any source in any manner after the insolvency commencement date. Why updation of the claims matters? Updating claims after the part or full satisfaction ensures. So this is about why the updation of the claim matters. Updating claims after the part or full satisfaction ensures the fair and accurate creditors list. We can update the list so that it will be fair and accurate list. A creditor cannot continue to vote based on a larger claim than what is actually owned. Yes, if the debt is paid off, then he must not enjoy the larger voting rights, which he do not deserve. Correct distribution. Obviously, when we update the time to time the list of the claim, then it will lead to the correct distribution. If a plan or liquidation occurs, distribution must be based on the real outstanding amount, not the stale claims. Transparency and integrity. The insolvency process reflects the true financial position of the corporate debtor. Regulation 13, this is the most important duty of the resolution professional. Regulation 13 says, the IRP or the RP, as the case may be, shall verify every claim as on the insolvency commencement date within the 7 days from the last date of the receipt of the claims, and thereupon maintain a list of the creditors containing the name of the creditors along with the amount claimed by them, the amount of their claims admitted, and security interest, if any, in the respect of such claim and update. So as per this regulation 13.1, within the 7 days, we have to verify the claim and maintain a list of the creditors along with all the details. Regulation 13.1a, sub-regulation 1a says that where the IRP or the RP, as the case may be, does not collate the claim, then he shall provide the reason, he shall record the reason. What was the, like, non-cooperation was there or whatever was the situation. In the event the claims are received after the period specified under the sub-regulation 1 of regulation 12, it is talking about what time period? Regulation 12.1. Regulation 12.1 was RFRP period. Yeah, this is what we have read. Up to the issue RFRP. This is 12.1. Up to the date of the issue of the RFRP or 90 days. So if he has not submitted within that period, then in the event up to the 7 days, he can submit in the events are received. If it is received up to the 7 days before the date of the meeting of the creditors for the voting on the resolution plan or the initiation of the liquidation, as the case may be, the IRP or the RP, as the case may be, shall first verify and categorize whether it is acceptable or non-acceptable for collation. The IRP or the RP, as the case may be, intimate to that creditor. हम किसकी बात करें? Claimants की, within the 7 days of the categorization thereof under sub-regulation 1B, and provide the reasons where the claim has been categorized is as a non-acceptable. If it is non-acceptable, then we will intimate. Otherwise, if we categorize as acceptable and call it, then it will be placed in the committee in the next meeting for its recommendation for the inclusion in the list of the creditors and its treatment in the resolution plan, if any, and submit such claims before the adjudicating authority for the condonation of the delay and adjudication wherever possible, applicable. The list of the creditors shall be available for the inspection by the person who submitted the proof of the claim. He can verify at any time, which is published on IBB website also. Available for the inspection by the members, partners, directors, guarantors of the corporate debtor also. Display on the website, if any, of the corporate debtor. Verification of the claims. Regulation CA 13CA file, it should be filed on the IBBA website, provided that this clause shall apply to the every CIRP ongoing or commencing after this and this. Filed with adjudicating authority. Obviously, we file and we have to intimate to the adjudicating authority COC report or if there is a revised report, then we have to intimate and present it at the first meeting of the COC. First meeting में तो constitution of COC report, and then if it is updated, then we have to inform reconstitution के case में. Points need to be verified. Points need to be verified, whether there is a debt, whether there is a time barred or not. We have to be verified that whether Limitation Act attracting or not. Verification and quantification of the debt based on the documentary evidence. Whether the debt is secured. If yes, RP will examine the details of the security. Whether the charge over the assets of the CD is registered, we have to verify that point. Now we will discuss and make the some discussion on the case laws. There is one case law, Greater Noida Industrial Development Authority versus Prabhjit Singh, Soni, Supreme Court, held on 12th February 2024. In this case law, there is some background that appellant was the Greater Noida Industrial Development Authority, GNIDA, who was the claimant a statutory authority here, constituted under the UP Industrial Area Development Act 1976. And respondent was Prabhjit Singh Soni, representing the SRA and the stakeholder also the stakeholder in the CIRP of the corporate debtor. And corporate debtor was the JNC Construction Private Limited as a real estate company. So what was happened? On the 28th October 2010,
Prabhjit Singh Soni was the RP in that matter.
Yes. No. Prabhjit Singh Soni was the representing the SRA.
No, he was RP in that matter. Actually.
Just a minute, there is a typo error. Maybe just need to check it. 1 minute.
Yes, I think Mr. Soni was the RP in that matter.
Yes.
Where it has been decided that, authorities will be secured creditors now. After this judgment only, they have demanded back all the plans back to COC.
Yes.
Yes.
Big
This
mess.
is the case.
That's
Yes.
a very big
The
case.
case. And this is the very famous case law. Let me- Okay, I will go through. There may be some, I think, typo mistake. Land on the 20th October, GNIDA leased plot number 1C, sector 16C, Greater Noida to the corporate debtor for the 90-year residential project. The lease required the CD to pay the premium installment at a prescribed dates beginning on 29th October 2012 and concluding on 29th April 2020 after the initial moratorium of the 24 months. These dues are subject to the interest and penal interest. GNC Construction defaulted on the payment of the installments and GNIDA issued a demand cum pre-cancellation notices demanding the overdue installments. A CIRP was filed against the GNC Construction and this admitted on the 30th May 2019. Following this, claims were invited from the creditors. Claimed GNIDA submitted the claim 43 crores, 40 lakhs, 31,951, representing unpaid installments of the lease premium and asserted it as a financial creditor in the CIRP seeking recognition accordingly. So he was claimed as GNIDA claimed as a financial creditor. Treatment of the claim by the RP. Classification as an operational creditor. RP treated GNIDA as an operational creditor instead of the financial creditor, and by the email dated 4th February 2020 directed the GNIDA to resubmit its claim in the Form B as per the CRP regulation, and GNIDA did not submit the claim in the claim Form B after this direction. Because the GNIDA did not comply the resubmitting the Form B, its claim was treated like as not properly filed in the form specified by the RP at the time. Resolution plan approval and claimed errors. Ultimately, the COC approved a resolution plan, which the NCLT also approved on the 4th August 2020. Incorrect acknowledgement of the claim. The plan incorrectly recorded that the GNIDA has not submitted the claim, and it also reflected a much smaller amount, and under the plan, GNIDA was to receive only 1 crore 34 lakhs. And an amount apparently by converting into the square root, what was the basis taken by the RP. Then GNIDA challenge in the NCLT and the NCLAT. GNIDA filed the two applications under section 60 subsection 5. One application IA 344 challenged the RP decision, treating it as an operational creditor instead of the financial creditor. It was argued and it was not informed about the COC meetings, contended that the plan did not treat its claim correctly and violated his rights. And IA 1380, which claimed that sought the recall of the NCLT order approving the resolution plan on the ground that the rights as a creditor were ignored. So NCLT decision, both applications were dismissed. The NCLT held that GNIDA had delayed raising objections. Now CRP already completed and plan is also approved. NCLT noted that the commercial wisdom is not justiciable. Then he went into NCLT. GNIDA appeal in NCLT and dismissed the appeal, and then matter went into the Supreme Court. Supreme Court held that resolution plan was set aside. The NCLT approval of the plan was invalidated because it did not satisfy the statutory norms under the IBC and CRP regulations. Plan returned to the COC to ensure that the creditor's claim are correctly verified and recorded. Supreme Court held that claim submitted is based on its own understanding of the claimant. Form in which the claim is to be submitted is directory, not mandatory. What is important is the claim must be supported by the proof. Even if the claim submitted by the creditor in a form which is not as specified in the CRP regulation, the same is to be given the due consideration by the IRP or the RP, as the case may be, if it is otherwise verifiable, either from the proof submitted by the creditor or from the records maintained by the CD. So it was just the matter of the claim form, and the matter went into the Supreme Court. So this case laws के लिए important takeaways for the RP. Substance over the form. Even if a claim is not filed in the exact form which is prescribed by the IBC regulations, it may still be considered. Proof of claim is more important and essential. The crucial requirement in supporting evidences such as agreement, invoices, ledger statements, codes, or the bank, these are the important element in verification of the claims. And RP's roles, RP must verify the claims based on the available records of the corporate debtor and whatever material available on record. So this is more important than the claim form. There is one more case law, Ashoka High-Tech Builders Private Limited versus Sanjay Kundra and ANR, in which case During the CIRP, the landowner filed its claim as a financial creditor. RP admitted the claim and the landowner becomes the member of the COC. So in this case, there was a wrong classification case. This is the case of wrong classification. The RP admitted the claim and the landowner become the member of the COC. It should be operational creditor. It should not be treated as a financial creditor. Subsequently, home buyers filed an application before the NCLT. Home buyers argued that the landowner should not be treated as a financial creditor. It should be removed from COC. He should not become the part of the COC. So NCLT allowed the application of the home buyer and directed the removal of the landowner from the COC, holding that this claim did not qualify as a financial debt. NCLT observation, what was that? The nature of the transaction determined the claims, obviously. Whether a creditor is a financial creditor depends on the nature of the transaction and whether it satisfies the definition of the financial debt. So merely filing a claim as a financial creditor does not automatically make the creditor as a financial creditor. Landowner in the real estate arrangement, the landowner has entered into a development agreement with the CD, where the consideration was sharing of the constructed area revenue, not repayment of the money, where the landowner contribute the land under a development agreement and receive a share in the form of the revenue constructed area. Such arrangement does not constitute the financial debt because there may be no disbursement against the consideration for the time value of the money, which is the main essential requirement of the financial debt. So RP's admission of the claim is not final. The tribunal observed that the admission of the claim by the RP is not subject to the judicial scrutiny and the adjudicating authority can review whether, because it is mentioned in the law also that the RP's role is not adjudicatory. It can be reviewed whether it is correctly classified. So incorrect classification can be corrected. If a creditor is wrongly admitted as a financial creditor, because if he is wrongly admitted, it will be the part of COC. So adjudicating authority can direct the removal from the COC. So final decision of the NCLT. The NCLT upheld the order of the NCLT and the tribunal agreed that the landowner should not be treated as a financial creditor. In the fact of the case, the landowner was directed to be removed from the COC. What was the reasoning? The reasoning was given that no financial debt arises as per the definition because there is a no consideration for the time value of the money. If it is, this is the which is the essential requirement for the 5.8. Development nature agreement itself described that it is it is not for the repayment of the money. It is not this agreement. The nature of this agreement does not define that it is for the time value of the money. It is not for the repayment of the money. And it is a wrong admission by the RP. He has not properly correctly verified the documents, not understood the document. So what is the key principle of from this case? A landowner's claim in the real estate project does not automatically qualify as a financial debt. If wrongly admitted as a financial creditor, then he may be removed. Practical importance for the insolvency professional, nature of the transaction must be examined before admitting a claim as a financial creditor. If a creditor is wrongly admitted, NCLT has a power to correct the classification. There is one more case law, Shailesh Sangani versus Goyal Cardoso versus Priority Marketing Private Limited. I think this is also related to the classification of the financial debt and operational debt. But there is some difference in this case. That fact of the case was that the CD received the money from promoters and shareholders, who was a promoter also and shareholder also. The money was advanced, but this money, promoter always give the money for the improvement of the financial health of the company. So we as a RP, we should understand that if promoter is giving the money to the CD, then it is obviously for the financial growth of the company. And financial growth of the company, okay, we will read and then we will understand. There was no provision for the payment of interest, okay. When he signed the contract, there was no clause of the payment of interest on the amount advanced. During the insolvency proceeding, the question arose whether this amount should be treated as a financial debt. The creditor claimed the status of the financial creditor. वो जो creditor था, promoter, he claimed that I should be treated as a financial creditor. The main legal issue before the NCLT was whether money advanced by the promoter, director, shareholder to the corporate debtor without an interest clause, because interest clause defines the time value of the money. So यहाँ पे interest clause नहीं है, तो can be treated as a financial debt under section 5.8. So what NCLT said, the tribunal discussed the concept of the time value of the money and explained that When the promoters or shareholders advance the money to the company, the benefit they expect, this is very important line, the benefit they expect may not always in the form of interest. It is in the form of, interest, not mandatory, interest is not mandatory, it can be in the form of enhancement of the company's asset, it can be in the form of increase in the production of the business operations, growth in the profits, increase in the share value or equity value. These economic benefits represent the return expected over the time, which the tribunal considered it is a time value of the money. So tribunal considered these aspects as a time value of the money. And if it fulfills these aspects, then it will be covered in the financial debt. So absence of the interest is alone does not automatically disqualify the transaction from being treated as a financial debt. So there may be some kinds of the interest. There may be some kinds. So in this regard, there are some citations also. Resolution professional has no adjudicatory power. Swiss Ribbons versus Union of India, it is clear from a reading of the code as well as the regulations that the RP has no adjudicatory power. Section 18 lays down under RP has to vet and verify the claims made and ultimately determine the amount of the each claim as per the regulation 10 to 14. Commissioner of Commercial Taxes West Bengal versus Nishant Gaurav Gupta IRP of the Suvidha Park Lift Limited. In this case, CIRP was initiated against the Suvidha Park Lift Limited under the IBC. The Commissioner of the Commercial Tax West Bengal filed a claim before the IRP for the recovery of the tax dues. The claim filed by this pertains to the tax liabilities that had arisen several years prior to the initiation of the CIRP. Because it's several years prior. Upon verification, IRP rejected on the ground that it is barred by the limitation. Whether the RP can admit a claim which is barred by the limitation? No. So, the NCLT Delhi bench held that IRP is required to verify the claim submitted by the creditors. If a claim is barred by the limitation, it cannot be admitted. The provisions of the Limitation Act apply to the proceedings under the IBC. It was held that was the decision given by the court. There is one more case law, Maxim Infrastructure and Real Estate Private Limited versus Income Tax Officer. CIRP of corporator was completed and the resolution plan was approved. The Income Tax Department initiated the reassessment proceeding for a period prior to the CIRP. So, resolution plan was approved by the court and then Income Tax Department initiated the reassessment proceeding for a period prior to the CIRP. The department had not filed the claim during the CIRP. Then NCLT held that if a creditor does not submit its claim during the CIRP, the claim stands extinguished after the approval of the plan. In one more case, Edelweiss as ARC versus Edel Landmarks Limited, CIRP was initiated against the Edel Landmarks Limited under the IBC. Edelweiss Assets Reconstruction Company Private Limited submitted its claim after the last date mentioned in the public announcement. RP rejected the claim, which is filed after the stipulated time. Whether the RP can reject a claim solely on the ground that it was filed after the last date mentioned in the public announcement. So NCLT held that rejection of the claim merely on the ground of the delay is not sustainable because the time limit is directly not mandatory, but IBBI के लिए mandatory है. Law says that it is directly not mandatory, but if we do not fulfill, then it is become mandatory. Therefore, the RP cannot reject a claim solely due to the delay because claims matter, evidences matter. Ghanshyam Mishra and Sons Private Limited versus Edelweiss ARC. In this case also, you know that Ghanshyam Mishra case, Supreme Court held that legislative intent of making the resolution plan binding on all the stakeholders is that after the approval of the resolution plan, no surprise claims should be flung on the SRA. It should start with a fresh slate based on the resolution plan approved. On the date of the approval of the resolution plan, all such claims which are not a part of resolution plan should be extinguished, and no person will be entitled to initiate or continue any proceedings in the respect of a claim which is not the part of the resolution plan. Claim against the guarantor as well as the principal debtor. I think some person has raised the issue regarding this. this claim is related to that two claims were filed in respect of same debt. ICICI Bank versus Ritu Rastogi, NCLT Bank. This is what old case law. We should go into. We will come into that. First, we will discuss the latest case laws. Regulation 14 says the determination of the amount of the claim. So there are some citations that the RP has an administrative power as opposed to the quasi-judicial powers. The RP is really a facilitator. In this matter, it is said that RP is a really facilitator of the resolution plan process, whose administrative functions are overseen by the COC and by the adjudicating authority. Under the CIRP regulations, the RP has to vet and verify the claims made and ultimately determine the amount of the claim. Regulation 14 says that where the amount claimed by the creditor is not precise due to any contingency or any other reason, the IRP or the RP, as the case may be, shall make the best estimate of the amount of the claim based on the information available within. The IRP or the RP, as the case may be, shall revise the amount of the claims admitted, including the estimates of the amount made, as soon as practicable when he comes across additional information warranting such revision. Whether RP can revise an admitted claim? Intech Capital Limited versus Uday Kumar Bhaskar Bhatt IRP of Atharva Auto Logistic Private Limited. Post admission of Section 7 application, the FC filed a claim of rupees 6 crore 52 lakhs 42,330, and the said amount was provisionally admitted subject to the verification by the IRP. During the verification, it came to light that the same FC had initiated the arbitration prior to the date of admission by the adjudicating authority. During the verification, it came to the light that the same FC had initiated the arbitration prior to the admission date. It was matter pending. Based on the amount reflected in the arbitration proceeding, the RP revised and reduced the admitted claim up to 3.16 crores. FC filed an application before the adjudicating authority, which was dismissed. On appeal, NCLT held that order of the adjudicating authority and held that 14.2 says that RP has a power to revise the amount. So there was a case law where the revision was done by the RP. So FC ने claim किया था 6.52 crore and provisionally admitted किया था. Subject to, obviously, if any further information comes across, then we can revise the claim. So it reduced the claim 3.16 crores, and this was upheld by the tribunals. This is the liquidation process. List of stakeholders. Yes. We come to this decision. Tata Steel Limited versus Varsha and ANR. Supreme Court decision 17th July 2026. Whether can an RP admit a disputed or uncrystallized claim at ₹1 and leave it open for the future crystallization? In this case law, it was determined. CD was the Bhushan Steel Limited, SRA was Tata Steel Limited, respondent claimant was Varsha and ANR. Case title was that, and it was decided on this date. So the background was that the case arose out of the CIRP of the Bhushan Steel Limited. Tata Steel was the SRA. Before the commencement of the CIRP, Varsha was then an operational creditor, has filed a civil suit against the Bhushan Steel Limited for the recovery of the 38.89 lakhs plus 18% interest. Another operational creditor, Mask Projects Private Limited, had initiated 6 arbitration proceedings against the Bhushan Steel Limited concerning the goods supply to the BSL. When CIRP commenced, both creditors submitted their claims before the IRP. Since the claims were sub judice and had not crystallized, they admitted at a notional amount of ₹1. What happened after the resolution plan approved? Tata Steel submitted a resolution plan which was approved by the COC, subsequently approved by the NCLT under Section 31. The issue arose. Even after the approval of the resolution plan, Varsha wanted to continue her recovery suit, which is filed in the civil court, and Musk wanted to continue his arbitration proceedings so that their claims would ultimately be determined and recovered. The Bombay High Court permitted the proceeding to continue. Tata Steel as a SRA challenged this before the Supreme Court. Main issue was that, what was the main issue before the Supreme Court? Can an operational creditor continue a civil suit or arbitration proceeding even after the approval of the resolution plan for a pre-CIRP claim which has not crystallized by the date of the approval of the resolution plan? The Supreme Court answered no, where the approved resolution plan did not preserve such claim because there is some reason. What was the reason of the decision? The Supreme Court held that once a resolution plan is approved by the court under Section 31, the claims dealt with by the plan becomes the final and binding on all the stakeholders. The SRA is entitled to take over the CDs on the claim slate, obviously. Therefore, an uncertain or unquantifiable pre-CIRP claim cannot be kept alive indefinite period के लिए and subsequently converted into the liability. It will, if it will be open-ended, then it will create the liability for SRA. The court specifically dealt with ₹1 notional admission merely because the RP had recorded a disputed or subjudice claim at a notional value of ₹1 did not mean that the entire underlying claim remained alive for future adjudication. The notional admission was essentially a mechanism for recording the existence of the disputed claim potential liability during the CIRP. So very important, this is the Supreme Court that practice that it recognized that such treatment can be used where the dispute is pending and the amount cannot presently be determined, but ₹1 admission does not give the creditor a right to continue the litigation in other court like the civil or arbitration. So you have to, because you para 55 says that the court emphasized that allowing the uncertain claims to resurface after the approval of the resolution plan would defeat the clean slate object of the IBC. The SRA must know at the time of taking over the CD that what liability it is assuming, and it cannot be exposed years later to unknown or unquantifiable liability. If they will continue arbitration, then they can that can increase the liability. That will not serve the purpose of the IBC. Para 60 and 61 says that the court ultimately held that where the claims had not become determinable and quantifiable by the relevant date and were not provided for in the approved resolution plan, the pending proceeding could not be used to revive those claims. So the claim which is pending before that court, that cannot be revived after the approval of the resolution plan. The Supreme Court therefore allowed the Tata Steel's appeals and sensitized Bombay High Court order and dismissed the Varsha civil suit as well as this MESEC arbitration proceedings, and this is recorded in the relief para 64. So we can discuss any question right now related to the claim, or it can be related to IBC regulations.
Ma'am, if a guarantor, I mean, applying the principle of, subrogation, pays any dues of the workman, then in liquidation, can that liability of the guarantor comes under Section 53(1)(b), or it will be treated otherwise?
53(1)(b की बात कर रहे हैं आप?
अगर वो वर्कमैन का ड्यूज अगर पे कर देता है तो उस केस में क्या होगा मैम?
Your question I actually आपका वॉइस भी थोड़ा रुक के आ रहा है, ब्रेक हो रहा है. So your question is
अभी सुनाई दे रहा है?
एक बार रिवाइज करिए क्वेश्चन अपना.
आपका जो वॉइस है ना वो थोड़ा ब्रेक हो के आ रहा है मेरे पास.
Madam, can once again repeat?
Can you type on chat box, please? Can you type on chat box so it will be easy to understand me?
Right, ma'am. Okay.
So please, I request you to please mention on chat box so that I can read properly. Have you mentioned?
Ma'am, I'm just so give me some time, ma'am. I'm just
Okay. Yes.
checking the same on the
You
chat
can
box.
just type and copy paste in the chat box.
Right, ma'am. Absolutely. I'm
Anyone else, if anyone want to like discuss anything?
Ma'am, can you share your PPT?
Yes, yes, I will share.
Please share the PPT.
Am I audible, ma'am?
Yes, yes. Please say loudly.
Yeah, I just had one query regarding the last case law that you just discussed, the Tata Steel and Varsha case law, where the claims are admitted at rupee 1 and uh, let us say there's a litigation going on in respect of that claim. What is the right course of action for the creditor? What
For
should
the
he do?
creditor, na?
Yeah, yeah. What
So
should he do? I mean, at the end of the day, he has to make sure that his claim is registered at a particular value.
अगर मैं क्रेडिटर की जगह होती ना सर, और अगर मेरा मैटर आर्बिट्रेशन में चल रहा है, इतने सालों से
Uh-huh,
चल रहा है, और अभी सीआईआरपी स्टार्ट हो गई है, मुझे पता है,
uh-huh.
तो आई शुड क्विट द आर्बिट्रेशन. आई शुड फुल्ली सबमिट माई क्लेम टू आईआरपी एंड ही शुड डिटरमाइन द क्लेम. आई कैन नॉट,
So
मतलब
that,
मैं दो जगह सवार नहीं हो सकती. और इस केस में क्या हुआ था कि उधर उसने क्लेम किया पूरा, एंड दे वर फाइटिंग देयर इन द आर्बिट्रेशन प्रोसीडिंग, एंड लाइक जस्ट फॉर एक रजिस्ट्रेशन पर्पज से 1 रुपए का क्लेम आरपी ने एडमिट किया कि टू एग्जिस्ट देयर केस. बट they decided they have to choose ultimately where they want to go. If they know that there is a last stage comes, approval of resolution plan process 180 days is coming to an end, they have to decide, they have to choose where they want to be, because the matter is sub judice. If after the approval of the resolution plan there is a no chance to revive the amount of claim. Before the approval of
okay,
the
I get
resolution
your
plan
point.
we can change the amount, we can update the claim. After the approval of resolution plan I cannot touch the claims.
Right, so I get your point. So that means that I should forego whatever is disputed and submit the
Yes,
claim that is likely to
yes,
be accepted.
because IBC override everything. Section 238, because why I when the CIRP is started, what I am expecting, if इतने
So,
सालों में मेरा अगर वो आर्बिट्रेशन का रिजोल्यूशन नहीं आया, तो देन आई शुड गो इनटू द आईबीसी फ्रेमवर्क.
yeah, but I remember reading in this case that Supreme Court also stated that in the revised claim list, I did not dispute the 1 rupee claim, therefore I cannot come back. So that means had I disputed the 1 rupee claim, then probably you see the RP or the adjudicating authority would have first adjudicated on that claim, not the RP but the AA.
नो, यहाँ पे सर मैटर ऐसा था, आफ्टर द अप्रूवल ऑफ द रेजोल्यूशन प्लान भी वो ऐसा चाहते थे, बॉम्बे हाईकोर्ट में उन्होंने ऐसा
मैं समझ
अपील.
गया, लेकिन रेजोल्यूशन प्लान पास होने के पहले भी जो रिवाइज्ड लिस्ट थी उसमें उनका क्लेम 1 रुपए पे आ रहा था
यस.
और उन्होंने इसको ऑब्जेक्ट ही नहीं किया.
हाँ, नहीं किया, ये यही यही. यस.
अगर ये लोग ऑब्जेक्ट करते
करते.
एए के सामने तो शायद रेजोल्यूशन प्लान अप्रूव होने के पहले उनके क्लेम पे एडजुडिकेशन होना चाहिए.
यस, यस. तो ये यही एक जो था, मतलब ये किसकी तरफ से फॉल्ट रहे, आरपी तो सर, आरपी विल नॉट डू एनीथिंग, ये क्लेमेंट
क्या
के ऊपर है, व्हाट ही
ये
वांट.
क्लेमेंट की फॉल्ट रह गई कि उसने ऑब्जेक्ट ही नहीं किया कि मेरा
ऑब्जेक्ट
एक
ही
रुपया
नहीं किया,
क्लेम पड़ा रहे.
बिकॉज सर दे आर नॉट अवेयर, they are not aware about the IBC actually.
राइट राइट. बट
So
आई लाइक द सजेशन दैट यू गेव फर्स्ट कि मुझे आर्बिट्रेशन से निकल जाना चाहिए,
yes,
अपना डिस्प्यूटेड अमाउंट छोड़ के एक्चुअल जो क्लेम कंपनी को एडमिसिबल है वो ही दे देना चाहिए,
yes,
बिकॉज
yes,
वैसे ही ओसी को कुछ नहीं मिलता है.
yes, that is the yes.
ठीक ठीक ठीक.
This question
ma'am, I
is
have
there in the chat box.
Yes, yes, I'm reading. So will you explain the question now? Because just a minute, just one minute, one call is there. 1 second. Yes, sir. Yes, sir. I'm just reading your question. If a promoter guarantor applying the principle of subrogation pays the dues of the workman, can the debt consequently to the subrogation now payable to the promoter under 53(1)(b)? So basically, 53(1)(b) says it is a priority given to the workman dues of the 24 months preceding the liquidation commencement date. So your question is like that: if the workman is like there is some outstanding on the part of the workman and promoter paid it, now the promoter can be the can be in the place of 53(1)(b). Am I right?
Yes, ma'am. I mean, the promoter is now comes under the shoes of the workman. Yeah.
Yes, but IBC do not provide like this provision, because if you have you seen the Excel format of IBBI claim sheet?
Yes,
If you
ma'am.
will see, like they have given a circular in
Ma'am,
PDF.
I'm just asking this question just to, I mean, get myself clear and nothing
My
else.
answer is no. My answer is no. My answer is no, because promoter will not get the subrogation right, and he cannot come in the place of workman.
I also considered that, ma'am. I also considered that.
Yes.
But still, I just want to get myself clear.
Yes, because if I need to record the decision, if I need, obviously I will record the decision, why at that time I have taken the decision so and so, then I should record the reason that there is a particular classification, right, in the IBC. There is a particular circular in relation to the claims that ये claim होगा तो इसको ऐसा priority मिलेगा, ये claim होगा तो इसको ऐसा. When the claim is not there, then why the right of the subrogation will arise, which is not given in IBC? So this
Ma'am, claim is there, ma'am. Claim is there.
claim
I
is
mean,
there, but
yeah.
claim is there, but now the claim is not there because the right of
Yeah,
subrogation is there.
once it is paid, yeah, once it is paid, I mean, it is not there. Absolutely.
So it may be the situation may be in a way the promoter has taken an assignment of claims. The other person has
Yes,
taken
yes,
assignment.
yes, yes. It
In
can be
that
treated
case,
like this. Yes,
yes. So in case of assignment, yes, then you can be in a position of
means इसमें सर ऐसा है कि वो अभी किसी भी फॉर्म में हो, गारंटी हो, सबरोगेशन हो, whatever, but he promoter cannot take the place of
say
workman.
yes, absolutely right, absolutely right. अगर कोई assignment में third party ले लेती है, then they can take it.
Yes, yes.
मैडम एक क्वेश्चन पूछें?
Yes.
मैं एक ऑपरेशनल क्रेडिटर हूँ who's secured by a bank guarantee.
ऑपरेशनल।
या आई एम ऑपरेशनल क्रेडिटर जिसको सीडी ने बैंक गारंटी दे रखी है. द बैंक गारंटी is you see my payment is due after the CIRP commencement date, say after 15 days of the CIRP commencement date. जब
आफ्टर द
पेमेंट ड्यू
कमेंसमेंट ऑफ CIRP। ओके।
आफ्टर द कमेंसमेंट ऑफ CIRP में मान लीजिए मैंने कोई गुड्स दिए हैं जिसकी ड्यू डेट जो है वो CIRP कमेंस बीच ड्यू डेट के पहले ही CIRP कमेंस हो गया.
अच्छा ठीक है।
ओके. और आई एम होल्डिंग ए बैंक गारंटी फ्रॉम द सीडी. तो
ओके।
मैं ऑब्वियसली अपनी बैंक गारंटी इन्वोक करूंगा.
नहीं
कैन
कर
दी
सकते
बैंक
सर, आपका
How can
नहीं
डेट ही
कर
you?
ड्यू नहीं
सकते.
हुआ। आपका डेट
नहीं
ही
कर
ड्यू,
सकते.
आपका डेट ही ड्यू नहीं हुआ ना सर।
नहीं, डेट जिस दिन ड्यू होगा मैं उस दिन बैंक गारंटी इन्वोक करूंगा.
ठीक।
नहीं. Section 14 will apply.
देखिए
No,
आपका
section 14 is
IBC,
a moratorium on the company, sir. How can it apply on the bank? The bank has issued the guarantee prior to CIRP. The bank is independently liable for my payment. So section 14 cannot apply here.
सर इसमें IBC में ऐसा है कि एज ऑन CIRP कमेंसमेंट डेट द
Yes,
डेट शुड बी ड्यू एज ऑन CIRP commencement date.
that's right.
So you cannot claim.
No,
You
the
be,
debt,
you are not the claimant in the eyes of the IBC.
madam, मैंने goods दिया, let us say before the CIRP commencement date, with a 1 year credit period, with a 1 month credit period, और उसके 15 दिन बाद में CIRP हो गया, तो मैं क्लेम नहीं कर सकता.
Sir, you
ऐसा तो नहीं होगा ना.
there is a provision. I will show you. क्योंकि सर ऐसे तो बाद में तो मेरी 1000 लाइबिलिटी क्रिएट हो जाएगी
नहीं
और
मैडम,
होती भी होगी।
मैंने गुड्स CIRP कमेंसमेंट डेट के पहले दे दिया. It's an accepted invoice with a due date falling post CIRP. How can I
No,
invoke
no,
a
he
claim?
cannot invoke the bank guarantee. He has to file the claim up to date of CRP only. This is only
Yes.
only the
Sir,
thing.
Yeah, bank guarantee will not be invoked. Yes.
बैंक गारंटी, यहीं पे मेरा आपसे क्वेश्चन है, बैंक गारंटी क्यों नहीं इन्वोक हो सकती?
And
बैंक
the bank
गारंटी
guarantee is made by the CD, na?
It is made by the CD, but it is made prior to the issue of the.
Let it be. That cannot
Bank
be. That
guarantee
has
is
to be
made
invoked
prior to
during
the
the CRP, sir.
CIRP commencement date.
That is fine, sir. That is fine.
Just let me complete. See, the bank guarantee is made prior to the commencement of the CIRP. Okay, so the bank has undertaken the liability, the obligation to pay. Now the bank will have to make the payment and make a claim on the CD. That is the point I'm trying to make. Bank cannot go back and say, and there's a case law for this. The bank cannot renege on the guarantee issued by it.
So what you want as a operational creditor?
So that's my precise point is that do you agree with this point or not? Whether the bank will be putting its claim in the CIRP, or does the operational creditor need to put the claim?
Sir, operational creditor can file the claim. Operational creditor can file the claim. If he has advanced the goods and services, then we will call for the information and you have to substantiate
No.
the
His question is, can we invoke the bank guarantee? This is the question.
Yeah, my question is clearly whether I can invoke the bank guarantee and realize my dues.
So in this case, just wait.
My opinion, no.
No,
Because in like in my earlier
I
case,
am
yes,
Vivek Sood. The section says clearly, section 14 doesn't provide only on the security in the contract of guarantee to a corporate debtor. If security of guarantee is there, that can be applied. So guarantee can be encashed. And that is a specific amendment came after a case law.
I think it will come under the purview of moratorium, bank guarantee.
It is an exemption under moratorium only. Even in a moratorium period, you can invoke the bank guarantees. It will not imply to the surety of the contract. Surety of the contract is banker.
For the
Which
simple reason,
of
madam,
which clause you are talking? Can you?
Section 14. Yeah, yeah. I will give you the clause. Just give me a moment. Section 14, 3A, 3B, sorry.
Section 14(3)(b), the provision shall not apply to the surety. Yes, yes,
Sure.
correct. Yes.
The
This is
surety is a bank. Yes.
the provision of the subsection 1 shall not apply. Yes, yes, yes.
so essentially my point is that the bank will have to submit a claim insofar as the payment made to the OC. That's the
Yes.
point I'm trying to make.
Yeah, the bank will become a financial creditor in that case.
That's right.
If bank guarantee is invoked, certainly bank will step into the shoe of the creditor in this case.
Yes, yes,
Yeah.
yes. So there is without provision, we cannot come to the conclusion. As RP, we have to check every provision.
Yeah. In fact, all I could remember was that there was some case law. I
Yes.
cannot pinpoint it, but I
Yes, there was,
remember
sir.
that
Sanjay
there
sir,
was.
what is the name of the case law?
I can't pinpoint it right now, but I do remember reading a case law like to this effect.
So whenever any situation comes like that, we just go through the like relevant case laws or what are the provisions applicable to particular that.
Yeah,
Because
yeah.
there may be some like situation may be different relating to the claims actually.
Yeah, I simply brought this up because a similar question was raised earlier by some gentlemen here.
Yes.
I just wanted to, put this to discussion. Thank you very much.
Thank you. Thank you. Any more questions I would like to invite? Related to not, we can discuss other than claim also. So one case law which I skipped, I just need to complete it. Claim against guarantor as well as a principal debtor. So there is a case law, ICICI Bank versus Ritu Rastogi. The CIRP was going on against the principal debtor as well as the guarantor. Two CIRP was going on simultaneously. ICICI Bank filed its claim with the RP of the principal debtor as well as the guarantor. RP of the guarantor rejected the claim that since the ICICI, since the same has already been admitted by the RP of the principal debtor, and if such claim is admitted, then then the recovery amount may exceed the total claimed of the ICICI, which may be prejudicial. What my friends would like to decide upon this? Ki when the like CIRP is going on against the debtor as well as and the guarantor, and we submitted ICICI Bank submitted the claim for both. So whether it can be whether it should be admitted as RP for like, can you deny that the claim is admitted by the principal debtor? Then why I should add this claim? Why should I admit the claim?
Can I say something?
Yes.
I think the RP cannot deny admitting the claim for the simple reason that in a number of decisions it is stated that the guarantor and the CD are both independently liable to settle the debts.
Yes. So in this issue, NCLT allowed the said claim since it falls within the definition of the financial debt, and RP is not allowed to raise any objection which is contrary to the provisions of the guarantee agreement. So RP has need to admit there is a no ground, yeah, there is a no reason. RP is not, because RP is not having the adjudicatory power. This is the point. RP have to perform his duties. If the claim satisfied, then he has to admit. He is not having any adjudicatory power. So there are, if any questions, we can discuss.
Ma'am, just asking you something for for clarification. It's
Yes.
not that I mean I mean, under the liquidation, if the liquidator, I mean, keeps any claim under verification, and while, I mean, keeping that under the under that status, if the liquidator continued with the sale of assets, then in that case, what will be the fate of that claimant whose claims will remain under verification?
So first of all, I would like to say that you have to conclude the claim. You cannot keep the claim under verification. Either you have to accept or you have to reject. Otherwise, NCLT will ask the question and will threaten the RP why you have kept under verification.
But
In
ma'am, if
within
it
1 month, 2 month, 3 month, you are in the same position.
but ma'am, if it is, I mean, subject
No,
to
you
litigation.
if you are not having the evidence up to the 2 months or 3 months, you are giving the time, unlimited time to the claimants to submit the information.
No, ma'am. I mean, if it is, I mean, subject to, I mean, litigation, court पे केस चल रहा है.
In my practice, I give the time of the maximum last reminders and last you were last, and now I just you are having the 7 days time. Otherwise, we will determine the claim as per the provisions of the code. This should be the step and action taken by the RP. Okay, when he is not responding, opportunity of
अगर
remedy is given, then we should reject. Why we are keeping the claims under verification?
पर मैम, अगर 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 कोर्ट पे केस चलेगा तो
Then you have to wait. Then you have to wait. I think.
कहाँ पे केस चलेगा?
कोर्ट पे अगर केस चल रहा है तो if it is under certain, I mean litigation,
हाँ, then तो we have a reason.
तो उस टाइम क्या होगा मैम? तो मैंने एसेट सेल तो कंटिन्यू होते रहेगा ना, तो उस टाइम क्या वो कि
सर
क्लेमेंट
वो
को क्या
केस
पैसा
चलता
नहीं मिलेगा?
रहेगा अभी डिस्ट्रीब्यूशन तो नहीं हुआ है ना, डिस्ट्रीब्यूशन तो नहीं किया है ना. बिफोर डिस्ट्रीब्यूशन वी विल डिसाइड.
अच्छा, अगर उस टाइम भी कुछ नहीं होगा तो
राइट, देयर कुड बी केस
we
की
cannot
डिस्ट्रीब्यूशन
distribute.
भी हो जाए, रजिस्ट्रेशन भी हो जाए और वो केस अंडर वेरिफिकेशन ही रह जाए.
नहीं, we cannot distribute until and unless the
You will not
amount.
distribute 100% actually.
We have to determine, we have to distribute as per section 53. Even if your claims are not decided, how you can distribute?
अच्छा.
That means until that case is decided where the amount of claim is under dispute, until that is decided, liquidator cannot conclude the liquidation
Cannot
until all the
conclude.
claims are either
Okay.
accepted, admitted, or
Yes,
rejected.
because claim is in question and liquidator is responsible to answer the matter in the matter. So it is, तो हमारी तो practice ऐसा ही है कि we just give the time, specific time. If he is not responding, then we will reject the claim. We cannot kept into the same status. And then we update the status on IBBI also. We upload the revised list that it is now, the claim is not under verification, so that it will be a updated list of the creditors. It will show that we are working, we are not sleeping. Because before distribution, no claim should be in the category of verification. Otherwise, it will be the fault of RP, it will be the fault of liquidator. You are still under the process of verification. Anybody can ask the question. Now the NCLT is asking like any question with RP or liquidator.
अगर वो कोर्ट पे केस अगर
Sir,
nowadays,
if some litigation is going on, then we have a reason.
nowadays, ma'am, the court cases are simply, taking, undue long time, inordinate time. And then
It is taking, but in the amendment.
आपके पास में अगर सेल प्रोसीड्स है, then जितना अमाउंट क्लेम का वहाँ पे लिटिगेशन में है, up to that amount you cannot distribute actually. You have
ये
to
भी हो
keep that
सकती है.
amount pending.
That is also possible. That is also possible.
Yes. This is the only
Right.
practical solution.
This is all because if it is taking very long time, then if you are thinking now it is on final stage, then you can wait.
Acha. Okay, ma'am. Okay,
It is
thanks.
depend. It is we can anticipate that the matter is at a final stage or whatever. A liquidator
People should upgrade this position. If he is sleeping position, that is not accepted. He should be updated the situation. What is the court status? What is the status? He has to submit all the detailed situations in that case.
I think we also have to see what is the kind of dispute. The dispute
Yes,
is as to the amount, or it is with respect to the, who is actually
classification. It
claimant.
can
That's
be,
the
yes.
classification. And
It
among whom this dispute is going on, that's another question which I want to ask. Where the dispute is going on, against who are the parties to the dispute? Is it between the company and the claimant only? I don't think that would be the case,
जनरली
because
जनरली delayed claims के मैटर होते हैं, classification of the claims के मैटर होते हैं. It can be, we
no,
can't
if any
anticipate.
IA is pending, certainly liquidation cannot happen. That is very sure. I think in this case, where the gentleman is asking, the dispute is going on in some other tribunal, some other forum, not before the NCLT, I think. Or do you
No,
It
no,
think?
may
absolutely,
be.
absolutely before the NCLT.
So
I,
then
I,
liquidation cannot
I
be
just can't.
completed.
I just can't. I mean, take the name now, but it is absolutely before the NCLT.
Yeah, it
But
can
if
be
any,
related to, and then
right, but if there is
actually,
I mean,
any
it is
IA,
on account of the claims only.
and if there
On
is
account
any
of the
IA pending, right,
on
if
yes,
there is
yes, yes.
any IA
IA is
pending
pending.
for the NCLT, then liquidation cannot be completed. Your liquidation application will not be disposed of by the NCLT unless disposed of first the IA which are pending there.
in the SEC meeting, you can do one thing. In the SEC meeting, you can take the approval of the SEC member for the distribution of the remaining amount as per section 53, if the SEC member agree.
Okay, ma'am. Right. Thanks, ma'am.
Anjali ma'am, can we close if there are no questions?
Thank you so much, ma'am. It was a nice
But ma'am,
presentation.
I hope you enjoyed the session.
Yes,
yes, sir.
absolutely.
Yes,
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 ma'am.
ma'am.
Ma'am. It was
Very good
wonderful
session.
session.
Thank you so much.
Thank you so much. Thank you.
Thank
So,
you.
Thank you very much, ma'am.
Thank you.
Thank
Thank
you
you.
very much,
Thank you,
ma'am.
ma'am.
Thank you.
Thanks,
The
ma'am.
session was very wonderful. Ma'am, kindly share the PPT of this
Yes.
session, please.
Yes, yes, of course.
Thank you, ma'am. Thank you.
Thank you.
thank you, ma'am. Very good session.
Thank you.